Hey guys, let me see if you guys are here. I just dropped a note in the other live, so if you're not here yet, you will be here eventually. That live had to be pushed back 24 hours because our guest had something else set for tonight, and when I had to push it back from noon today, it was supposed to be at noon today, and my schedule got messed up, and then we pushed it to 6 o'clock, and then she's like, I actually have something at 6 o'clock, parent teacher meeting, so that pushed it back to tomorrow. So my bad, guys. She actually just called me like 20 minutes ago, and I was like, don't worry about it because it's my fault. So since we talked about doing this, I'm going to go ahead and take this time to do it now. um, Anyone who's here now, I'll tell you guys. So anybody on the replay, you're gonna know, and you'll know for tomorrow. Obviously, I feel like you could get a hint from the trailer in the live of who was coming. We were talking about the nurse that got arrested at Fulton County. So uh we're going to get some she's going to retell us the events of what happened leading up to the situation. This is the nurse that was accused of having a inappropriate relationship with an inmate, and tell us what she's doing now, what happened, tell us what's true, what's not true. Yes. I'll tell you guys cuz you guys are here. You guys got here right away. Um she basically reached out to me on Instagram. So she reached out on Instagram and basically wanted to tell her side of the story because she's just like, it didn't happen like that. And I said, well, first we only know what we heard on the local news. Then I did get the arrest affidavit. So this is according to the sheriff's department. So anyway, we're going to talk about it. I don't want to tell too much, but she has a very interesting story to tell. And I think you guys are going to really be like, what? So we will see her tomorrow. She's very nice. Maybe she'll be bougie gang afterwards. You know what I'm saying? I can't say she'd heard of us previously. I didn't even ask her. I didn't even check to see if she's following my channel. I'm going to be honest with you, or see if she was following my Instagram page. I would imagine maybe she is now. Maybe she just found me because of the social media, because she said that she's been kind of tracking and looking at the social media surrounding the events, and all of the things. I don't want to tell too much. I want her to tell her whole story tomorrow, but she wants to talk to us. Okay, so I'm gonna leave that right there. I don't want to say too much, and but you guys know, and anybody who clicks in. So it's gonna be the same live tomorrow. I told her, I said, I'm not gonna change anything. Just click the same link. I'll call you tomorrow at 5:45. It's the same link for tomorrow at 6 p.m. Eastern. So my bad, guys. And let me share my screen. You guys wanted a reading of the transcript. We read this like 3 months ago, but you guys, Bougie Gang gets what Bougie Gang asks for, right? If closed mouth does not get what? Fed, right? You guys asked for it. If you guys want, girl, we can do it. We read this back on October 28th of 2005. This is the transcript of the day that Shirley Strawberry showed up to court. Okay. So you guys said you wanted to replay this. Is this not correct? This is what you wanted to replay? Is this it? Am I replaying the right one, or what was it? Don't make me say it again, Tanya. I'm going to say it one. The nurse from Fulton County who got fired last week. I don't want to say it too many times because I don't want to. I don't want to say it too many times, but the nurse who got into the drama at Fulton County, and we talked about it last week. Okay. Yes. Okay. You're okay. She'll be here tomorrow. Okay. Anyone else coming in who's like, what's going on? Tell them to hit the bar back. And then we will be seeing everybody tomorrow on that topic. Okay. It's going to be good. Okay. 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 Okay, girl. Okay. All right, you guys. Is that what we're supposed to be? It's the motion to suppress transcript. Is that correct? You guys wanted to hear this again. Is that right? I'm about to go to bed now, so tomorrow I can hurry up and get in here. Okay. All right, let's get into it. We're going to do a replay. Tiny be here to reschedule the nurse from Fulton. Thank you, baby. Okay. Bible lady, you better not leave. You better not leave. Okay. Hi, Leah TV. Hey, boo. Okay. Somebody asked, was it going to be Joey Sea Dog? No, I haven't. I have not seen Joey Sea Dog in the chat in a while. I don't know if you guys ran our friend off. Maybe he'll be back one day. You know, I'll put the bat signal out. Um, so he can come back with his unpopular opinions. Maybe he'll share, not share. I don't know, but well, I'll send out a bat signal. Okay. I'll send out a bat signal. Okay. Okay. Yes. Like Candyman? Okay, Justin's mom, I'm not gonna say it, but you know what I'm saying? Like you can't, look, let me be quiet. Bougie Gang, please hit the thumbs up. Okay, are we this is what we're doing. You guys wanted a replaying of the transcript of the motion to suppress. Can I get some ones in the chat? Is that what we're doing? I did find a very funny episode. I have another throwback for you guys. That I think I was listening to it in the kitchen and I was like, this is so funny. But I'll save that one for next week. Maybe we'll do a throwback a week or something. Since we've been doing this for like a long minute now, we do have some very funny throwbacks where you guys were in rare form and made me act extra, extra silly. And on some Nesto or just even on some other stuff, if there's a throwback that you love, like love, 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 for either it was super funny or super informational, make sure to throw it in my direction. I feel like our good sis KK Scorpio has sent me a couple. So I'm kind of compiling a little bit of a list, and maybe if that's something you guys want to do, we can do some throwbacks, maybe because it's Black History Month, right? So we're making our own history, and maybe we'll go through our throwback history, right? Maybe it's Throwback History Month over here on Real Talk Bougie. So we might hit some throwbacks here and there, maybe once a week or something. So we'll see. Okay. Vicky is calling the name. Who is that? Wait, I'm sorry. Jay Vickers. Jay Vickers is calling out the name. Okay. She's throwing out the bat signal. We shall see. Bougie Gang stay on Nesto's neck. Okay. Bougie Gang stays on Nesto's neck. Okay. All right. I swear I hollered so much at the one last week. You were in rare form when Nesto was girl. Those messages were ridiculous. Okay, I've told you guys my favorite Nesto episodes. Okay, my favorite Nesto jail calls. Number one is Shirley telling Nesto that they came to the beauty salon. Okay, that's a favorite. And her basically dropping all the tea about them calling Ty at Danielle Diamonds. That is like the best call ever. Another funny call was when Nesto read his letter to Crail Lewis. The letter to Crail Lewis, I almost peed in my pants. Probably the first 3 times. Like that was hilarious. Nesto's epic rant, the 5 calls to Blabbermouth. the epic 5-part 30-minute each phone call that made it into the Will Wooten response to a response to a response to a response. It was so damn long and so damn heinous that it had to be documented by Will Wooten into the paperwork. What else? Dion calling Sonya all kinds of bitches. Sonya telling Nesto that Dion called her a bitch in a disappearing Instagram message, and then Dion telling his father. Ah! Okay. What else? I guess that's top 5. That's my top 5 today. Ask me in 6 months, it might be something different, but I feel like my top 3 really doesn't change. My top 3 really does not change. If you're on the replay, comment your top 5. If you don't remember the episode, if you just kind of loosely remember what happened, just comment your top 5. If you have links, we can't replay everything, but we can. Oh, why am I all of a sudden having like a little damn TMJ or like some sort of tooth situation going on? What is going on? Okay. Ugh. You know how all of a sudden like a tooth starts acting funny? Like, okay, wait a second. Okay. Okay. Will there be a marathon of your faves? I feel like we did that recently. Did we not do that, guys? I'm going to have to go back and look. I feel like we recently did something like that, but it's a possibility. What's coming up next? What's the next Nestiversary? The next Nestiversary is going to be his indictiversary, which will be 2 years that he got indicted on the RICO. So maybe by the indictiversary. How about we do that? By the time that it's 2 years since he got indicted, because that's going to be right around the time that he is going to go to court again. Allegedly, well, it's not even alleged. He has a court date on April 15th, and his indictment anniversary is right around that time when he got his indictment for the RICO. So let's plan for my top 5 by then. That'll give us roughly 2 months, and maybe we'll go through one throwback a week until we get to the penultimate date, which will be whatever date that is in April. That's his indictment anniversary. Is that like a deal? I'll have to put that on the calendar so your girl doesn't forget. Dre tells Nesto they're going to have to take a ride. Really? That's the one. When he said we're going to have to take a ride, when he just kind of was like, you're going to have to explain to me this. You're going to have to explain to me them pictures. I don't have any money. Oh, I don't have any money. And Dion saying, they getting baptized your ass. Dre telling Nestor they're going to have to take a ride. Hey, can I get $50,000 for my bond? You're going to have to talk to me. And then Sonya's like, he's an asshole. My absolute favorite is when Dion was mad as hell and hot from washing cars. The silver bubble jacket video is just plain embarrassing. I do like the first few tablet visits were a key. Okay. Greetings, Bougie Gang. Hey, boo. Dion telling Nesto she's weird. She's a weird hoe. Dion was hot. Dion's tried to tell his dad how he felt for a long time. When Dion has Salt and Pepper join the call. Okay, the damn Metro PCS girls. Okay, definitely I don't have any money, and the reading of the text messages. Dre call where he told Nesto Sonia called him for $15,000. Them folks ain't built like that, referring to Shirley. My favorite 2155. I don't understand Nesto to Sonia. Let's see. Him explaining to Dre the English word Nola. No, who said okay the other day Nola process when Nesto gave Shirley the number. Oh, Connect Network. We've got some history, guys. Okay. All right. The word in the one with Dre went off on Nesto. Okay, like Nesto, I heard it. It wasn't no AI. I heard this is what you said. It's not maybe I said that's when Nesto lied to Dre, when Dre told Nesto that they call him Nasty Nesto. Oh, well, you can hear that right now. Hold on a second. You can hear that one right now. Hold on. Catch this. Look at this.
But me, I just dogged down all the way around. Nasty Nesto. I'm telling folks, man, I ain't did nothing with these folks, man. Hold on,
What's your name, Nesto? What's your name, Nesto? You know what? You know what?
What?
It's funny that you said that. You just brought back some memories. So when you said that, when I told you, I think on a couple phone calls back. Remember I told you, I said, you know what they call you right here? Yeah, you say what?
They call me Nasty Nesto.
I said they call you Nasty Nestos, right? However I said it. So
Yeah.
they don't took my voice.
I can speak to that. As to 23 CP 215407, at our last hearing, the state did move to null process or to decline that particular case. We will just revive that case in an indictment.
And they did.
What's your name?
And they did.
They call me Nasty Nesto.
What's your name, Nesto?
They call me Nasty Nesto or some shit I ain't do.
You know what?
You see what I'm saying? They call me Nasty Nesto. Okay. All right, you guys. You guys requested, and okay. You guys requested, so here we go. Hold on a second. Let me make this big. Okay. I don't know where this starts at, but let's figure it out. Hold on. Let's see. Period. Okay. Uh-oh. Let's read this temper tantrum free. Okay. If you know, you know. Okay. If you're new here, I think I was still on the effects of, I was still annoyed that somebody had disrupted the video footage. The video footages, I'll give you a clue. I'm just going to give you a clue that I was probably still annoyed that somebody had disrupted the video footages and I was talking my shit. Okay. So don't pay any attention to me. I was being Virgo emotional. I was fully in my Virgo and I was annoyed and I could not hold my tongue. So just ignore me. Okay. I was in my feelings. Yes, about the footages. Okay. All right. Okay. Welcome. Make sure to hit the thumbs up. We are reading the transcript from the last hearing for Ernest Williams, who has a RICO situation amongst others. And in Fulton County, he is the ex-husband to Shirley Strawberry from the Steve Harvey Morning Show. You know Shirley with the strawberry letter. Her ex-husband, her not so long ago ex-husband, is in a just a shit storm and hot water. And ma'am needed to come and testify because he's trying to implicate our girl Shirley. he's trying to implicate Shirley in some foolishness, and no. Okay. So she had to come and testify, and that's what it is. So this is the testimony on that day, and let's get into it. Okay, so good morning, Mr. Williams, the court. So that's the judge, right? The court is Judge Dunaway. Okay. Good morning, Mr. Williams. If I'm not reading, forgive me, because you guys talk to each other. Everything is on the screen. Okay. Thank you for supporting. Thank you for supporting. Okay. All right. Let's get into it. Good morning, Mr. Williams. Attorney Hoover is present. The state is here being represented by the DA's office. There are 2 cases, 2 indictments pending against Mr. Williams. Mr. Williams, Attorney Hoover, on May 20th of this year, the grand jury indicted Mr. Williams in indictment number 25SC003194 with rape, aggravated sexual battery, aggravated sodomy, and trafficking a person for sexual servitude. Attorney Hoover, how do you all plead to this indictment? Mr. Hoover, Your Honor, Mr. Williams pleads not guilty this morning for 25SC003194. Do you need me to read out all of the charges and give them do you want a formal arraignment, or how do you want it? Mr. Hoover says, we will waive the formal arraignment. Okay. All right. So Mr. Williams, your lawyer, you have a new case, number 25 SC case. We'll give you and your lawyer time to discuss that case, opting into discovery. And I want to make sure that we at least handled the arraignment portion, and that you knew that you had a second case pending against you at this point in time. Keep in mind, at this moment, the Strawberry indictment and the PGR indictment were not yet. Okay. Are we clear? Just keep that in mind, that the Strawberry indictment and the PGR were not yet a thing. Okay. This exercise is what fooled around and got him another 2 cases. Okay. So this will all be explained. If you're new here, just sit back, get a snack, and just soak it all in, because it's a lot to absorb. This man has a few complicated cases. Okay. But just for all of the people who have been here, the Strawberry indictment and the PGR were not a thing yet. Okay. Let's see. At least handled that portion, that you knew that you had a second case pending against you at this point in time. All right. So now let's turn to case that's been here, 24 SC 001723. We had Attorney Hoover filed a motion to suppress. We had the hearing. There was a supplemental briefing filed by the defense in January of 2025, laying out all of the defense believes should be suppressed based on the hearing. And then in April of 2025, the state filed supplemental exhibits to the hearing to the motion to suppress. I understand, Attorney Hoover, you object. You have objected, and you still object to the court continuing and reopening the evidence portion of the motion to suppress hearing. Is that correct? And Hoover says, yes, Your Honor, that is correct. You guys, I'm just going to make this one interruption, because keep in mind, this video is 3 hours and a half. So it's like a long movie. Okay. Yeah, this video is basically a movie. Thanks for coming. That's what I'm going to say. Number one, thanks for coming. I'm going to interrupt minimally When you hear and see me talking in the circle, that is on October 28th when we read this transcript that was originally from, I believe, in, I'm not even going to say a date because I don't want to get it wrong, but it was the reading of the motion to suppress hearing that occurred earlier, a month or so earlier. So that is where we're at right now. We're at 1957. Hold on a second. Let me see. Did it say? Now I feel obligated to give a date. Hold on. Let me see. Yesterday. All right. Okay. This was, so the original reading of this. We'll just, okay. Easy. You know, possibly can. Yes. Okay. Hold on. So this, okay, the official proceeding of a motion to suppress hearing before the Honorable Judge, the Honorable Eric Dunaway, Judge, Fulton County Superior Court. Can y'all hear me? Okay, y'all can hear me. Okay. Courtroom 4F, Central Avenue in Atlanta, Georgia, commencing at 9 a.m. on the 11th day of August 2025. Okay. All right. Are we clear? This was on the 11th day of August 2025. The actual reading of this particular document took place on October 28th because there had been a temper tantrum filled tirade on the day that this event took place, and the people of the YouTube streets wanted to hear this without the bullshit. Okay. And that's what we did. All right. So that's what we're playing now. If you're just now coming in, you're not too late. Welcome, welcome, welcome. We're about to get into it. I just wanted to be clear what this was, where we are in time. This is an episode from October 28th, but the motion to suppress hearing took place on the 11th day of August of 2025. Are we clear? Okay, are we clear? Hopefully we are clear. And I'm going to interrupt minimally because if I interrupt, we'll be here till midnight, and we're not doing that. We're not doing till midnight, okay? Let me put this. Let me fix this. Motion to suppress transcript reading of hearing 11th. 8 11 25. Okay. I think we got it now. Throwback episode, because anyone who comes in, throwback episode replay, October 28th, 2025, motion to suppress transcript reading of hearing 8 11 25. It can't get more clear than that. Okay, it's on the screen. I'm going to let y'all have it. I'm going to be watching and listening too, but I'm good. Like I said, I'm going to interrupt minimally just so we can get all of, let's just get refreshed on all of this good tea, right? Okay. All right. I'm going to go back to, well, let's depending, you know, all right, guys, let's get into it. Let's see. Okay, we'll just start right here again. You guys, welcome, welcome, welcome. If you're just now coming in, we're just getting started. Hit the bar back if you want to catch everything of the last 30 minutes. If you want to know where our special guest is, all of the things, slide back, baby. Slide back. Go ahead and slide back, or just jump right in, and then just know at that 30-minute mark is where you can, you know what I'm saying? This is where we're starting now. So if you didn't come in 30 minutes ago, you know where to go back to. Okay. All right, guys. Boom. Let's get back started. Welcome. Welcome. Hit the thumbs up for me, please. How far we go. Let's read Shirley's testimony uninterrupted, without foolishness, shenanigans, interruption, and temper tantrums. Okay. All right. Period. Okay. Let's read this temper tantrum free. Okay. If you know, you know. Okay. If you're new here, Welcome, welcome, welcome. Make sure to hit the thumbs up. We are reading the transcript from the last hearing for Ernest Williams, who has a RICO situation amongst others, and in Fulton County. He is the ex-husband to Shirley Strawberry from the Steve Harvey Morning Show. You know Shirley with the strawberry letter. Her ex-husband, her not so long ago ex-husband, is in a just a shit storm and hot water. And ma'am needed to come and testify because he's trying to implicate our girl Shirley. He's trying to implicate Shirley in some foolishness, and no. Okay. So she had to come and testify, and that's what it is. So this is the testimony on that day, and let's get into it. Okay, so good morning, Mr. Williams, the court. So that's the judge, right? The court is Judge Dunaway. Okay, good morning, Mr. Williams. If I'm not reading, forgive me, because you guys talk to each other. Everything is on the screen. Okay. Thank you for supporting. Thank you for supporting. Okay. All right. Let's get into it. Good morning, Mr. Williams. Attorney Hoover is present. The state is here being represented by the DA's office. There are 2 cases, 2 indictments pending against Mr. Williams. Mr. Williams, Attorney Hoover, on May 20th of this year, the grand jury indicted Mr. Williams in indictment number 25 SC 003194 with aggravated sexual battery, aggravated sodomy, and trafficking a person for sexual servitude. Attorney Hoover, how do you all plead to this indictment? Mr. Hoover, Your Honor, Mr. Williams pleads not guilty this morning for 25 SC 003194. Do you need me to read out all of the charges and give them do you want a formal arraignment, or how do you want it? Mr. Hoover says, we will waive the formal arraignment. Okay. All right. So Mr. Williams, your lawyer, you have a new case, number 25 SC case. We'll give you and your lawyer time to discuss that case, opting into discovery. And I want to make sure that we at least handled the arraignment portion, and that you knew that you had a second case pending against you at this point in time. Keep in mind, at this moment, the Strawberry indictment and the PGR indictment were not yet. Okay. Are we clear? Just keep that in mind, that the Strawberry indictment and the PGR were not yet a thing. Okay. This exercise is what fooled around and got him another 2 cases. Okay. So this will all be explained. If you're new here, just sit back, get a snack, and just soak it all in, because it's a lot to absorb. This man has a few complicated cases. Okay. But just for all of the people who have been here, the Strawberry indictment and the PGR were not a thing yet. Okay. Let's see. At least handled that portion, that you knew that you had a second case pending against you at this point in time. All right. So now let's turn to case that's been here, 24 SC 001723. We had Attorney Hoover filed a motion to suppress. We had the hearing. There was a supplemental briefing filed by the defense in January of 2025, laying out all of the defense believes should be suppressed based on the hearing. And then in April of 2025, the state filed supplemental exhibits to the hearing to the motion to suppress. I understand, Attorney Hoover, you object. You have objected and you still object to the court continuing and reopening the evidence portion of the motion to suppress hearing. Is that correct? And Hoover says, yes, Your Honor, that is correct. Judge Dunaway states, okay, all right. I know that the defense objects, but over the objection, I will reopen the evidence portion of the hearing and allow the state to present further evidence. ADA Wooten, thank you, Judge. Would you like us to just jump right into it and call our first witness? The court. I believe I understand the issue because I read through your motion. You're saying that Mr. Williams lacks standing to even challenge the suppress to search of the vehicle. And if he lacks standing, then we don't even get into his right to be free from search and seizure. That is correct, Judge. Okay, then Mr. Hoover, is there anything you would like to add other than your objection? Just the objection. We would also like to invoke the rule of sequestration as well, Your Honor. So the rule of sequestration means that if there is anybody in the courtroom who is testifying on that day, they should leave the court and go sit outside or elsewhere until they're called, because whichever side is requesting sequestration doesn't want that person exposed to other testimony that will be happening in that hearing on that day. Once you've given your testimony, you can usually sit in the gallery and it's not a problem. But if you're in the gallery and you're testifying, basically that means leave. Okay. Just the objection. We would also like to invoke the rule of sequestration as well, Your Honor. Okay, all right. If there are any witnesses, please step out. All right, Attorney ADA Wooten. Judge, the state calls Shirley Strawberry. Hold on a second. I need to use a sound effect on that one. The state calls Shirley Strawberry. When that happened, that was kind of a little bit of a moment, because it was like, oh shit, Shirley's there? Oh shit. Okay. Yes. Whereupon the witness is sworn. You love the drums? Me too. Me too. Is it just my internet messing up? Is it? Dun, dun, dun. Is it? Tell me now, guys. If El Cid, go ahead and leave and come back in, baby, or whoever that was. Muffin 218, baby. Let me see. Oh no, was I not in the you guys couldn't even hear me. Oh my God. Okay. I was saying, thank you to everybody who just contributed. Thank you guys. I was saying that all of the defenses. Wait, I was also saying that we're going to be here all night. I better stop interrupting. I was also saying freedom's not coming soon. I said thanks to Reef and Muff's mom. That's why I'm not going to interrupt because I actually took myself all the way out the live. So now I'm totally messing up. So let me just leave you guys alone. I just wanted to know if you guys could tell the difference between the comments of today and the comments of the original live. So this comment right here, Justin's mom, that's a today's comment. Muffin 218, that's an old comment. Okay. Can you guys tell? This is new, Reef and Muffs. The ones that are in the bubbles. That's why I kind of changed it to bubbles. Whispering, infamous blabbermouth, infamous blabbermouth. Okay. So when I highlight, these are new comments. Some of these comments are old. Okay. All right. And these are old comments because we're rerunning a live from October, right? Okay. Okay, guys. All of the defense believes should be suppressed. I think everyone is saying that they're good. It might just be you, boo. Okay. I don't know if KK Scorpio is here. Let me see. I have a birthday song for KK Scorpio, or should I wait till the end for all of our Scorpios' birthdays? Hold on. I heard this rendition of Happy Birthday and I thought about you guys. I'm going to read it as it states. And then with Shirley Strawberry script, okay? It was muffled. Okay. We'll fix it for next time. Will Wooten know that he can call his first witness, and Will Wooten says, Judge, the state calls Shirley Strawberry, okay? Whereupon the witness is sworn, okay? Bailiff, ma'am, if I can get you to state your name and spell it for the record, please. Shirley Strawberry. Shirley. Strawberry. Strawberry. All right, thank you. You may have a seat, please. Shirley Strawberry, having been first duly sworn, was examined and testified as follows. This is the direct examination by Mr. Will Wooten. And then we go into question and answer. Good morning, Miss Strawberry. Good morning. I am going to start out with some introductory questions for you, and then I'm going to read it as it states. And then we're probably going to jump into some of the substance, okay? So, are you familiar with Ernest Williams? Yes, I am. How are you familiar with him? Well, a few years ago, I was married to him. When approximately, or if you know the date, did you marry Ernest Williams? January 9th, 2025. And on January 9th, 2015. And on January 9th, 2015, did you have any reason to know that Mr. Williams was married to anyone else at that time? I did not. And have you since learned that he was married to someone else at that time? Yes. Okay. In fact, do you know that he was married to more than one person at the time that you married him? I know now. I didn't know then. And are you still married to Mr. Williams? No. Can you explain to the court what happened? And I'm just talking strictly to the marriage, the divorce, the grounds for the divorce, and when that was granted. I divorced him last year, August of 2024. And okay, was one of the grounds for divorce these other marriages that were still Mr. Hoover, Your Honor, I'm going to object to the leading testimony or nature of the question. All right, I'll sustain the objection. Can you explain the grounds for the divorce was? Yes, because we weren't legally married as I understood. Your Honor, I'm going to approach with some exhibits as a preliminary matter. I want to make sure that everyone is in agreement that the rules of evidence don't apply in a suppression hearing. I've got some case law on that, but I'd like permission to just go ahead and use these exhibits, not lay any foundation or anything. I don't think that's required at this juncture. Okay, do you have the exhibits? Do you have a copy of them? Yes, they have been shared with the defense. Okay, just ask your questions, use the exhibits. If there's an objection, then I'll take up the objection. Judge, may I approach the witness? Yes. Ms. Strawberry, I'm showing you what's been marked as State's Exhibit 1. And Judge, may I publish State's Exhibit 1 at this point? And what is it? It is a motor vehicle credit application and basically a sales contract for an F-350 that's at the heart of the issue. So, Your Honor, I understand that the rules of evidence, Mr. Hoover. So, Your Honor, I understand that rules of evidence do not or don't apply for this suppression motion. However, the witness has to at least acknowledge that she knows what we are talking about before I believe that anything should be published to the fact finder, which is you in this situation. Okay, I'll let you ask the witness some questions about it. Judge, I've actually got case law that says that's not the case. The foundation is not required. Authentication is not required. I can present that to the court. The reason why I'm doing this is because she's actually not familiar with it. It was done without her knowledge. So that's the point of showing her the exhibit, to walk through and have her explain that she did not see this until she came to court or until we discussed it in anticipation of court today. But she can't authenticate the document, and that's kind of the point of the whole thing. And I can't provide the case, and I can provide the case law on what if the court would like. All right. Oh, so right. And don't know there's a need to publish it, but I'll allow you to ask her questions about State's Exhibit 1. If she has a copy, then I'll let you ask her questions about it. I don't know if there's any need to publish it in open court at this point in time. My concern, so Wooten says, my concern is just that the court is not able to see it. I have your motion that you have attached exhibits to. Okay, so I think I'm with you. Okay, that makes sense. Judge, I can do that. Question by Mr. Wooten. All right, Ms. Strawberry, I want you to take a look at what I've shown you, and it's been marked as Exhibit 1. Can you read what the title is at the top of the document? Retail motor vehicle credit applications. Okay. And when did you first become aware of this document? Answer, aware of the document? Yes. Right now, since you gave it to me? Okay. And did you at any point, and we'll get to the specifics, but did you at any point give anyone permission to purchase ever a Ford F-350 vehicle in your name using your information? No. Okay. And so the document that you have in front of you, Exhibit 1, do you see there's a box at the top that says credit application applicant? Yes. And there's a first box that has a name. Do you see that? Yes. Is that your name in that box? Yes, it is. And do you see next to that there's a box that has a birth date? Is that your date of birth? Yes. And do you see a social security number? Yes. And is that I think you just see the last 4. Is that your last 4? Yes. Okay. Did you ever give anyone permission to use your name in the purchase of a vehicle? No, I did not. What about your date of birth? No. And what about your social security number? No. So I'm going to move down a little bit at the bottom of the first box. Do you see there's a box labeled home phone? Hold on. Let me read that off screen. Do you see a box labeled home phone? Yes. Could you read that home phone number is, please? Ending in 2829. Is that your phone number? No. Has it ever been your phone number? No. Do you know whose number that is? I do not. And then to the right and just a little bit, there's a box. Do you see a box that says preferred email? Yes. Could you read what the email is? I might need my glasses, but I hold on me a second. I think it's an email address at yahoo.com. And what is your email? Is that your email address? No. Has that ever been your email address? No, it is not. Just a second, guys. No, it has not. Do you know whose email that is? I do not. And then it says unidentified female. Your Honor, may I approach with Miss Strawberry's glasses? If she needs them, yes. I might. Thank you. Miss Strawberry says I might. Thank you. And so just moving through the document, I'm going to go down to the second box. Do you see what I'm talking about? Yes. And do you see towards the bottom of that, there's a line that says nearest relative? Yes. And could you read the name for us? Please, of what's listed there, Carlos Lamont. Do you have any relatives named Carlos Lamont? No. Do you know who Carlos Lamont is? No. Do you have any knowledge of Mr. Williams having an associate or friend named Lamont? Yes. Could you tell us who that person is? I just know him as a friend of Mr. Williams, and I didn't even know his name was Carlos. Oh, and do you see a number that do you see under that line which Carlos Lamont down and over just a little bit there's a box that says phone number and she says yes. Okay, hold on a second. Once we get through this, I'll be able to stop having to do this, but and the number is ending in 0141. Yes. Do you have any knowledge of whose phone number that is? And she says, and the phone number is ending in 0141. She says, yes. Question, do you have any knowledge of whose number that is? No. Now, moving under another line, there's a line that says additional reference. Do you see? Do you see that? Hold on one second, guys. Additional reference, right? Okay, additional. Portia might not want to go out. Additional reference, right at the very bottom. Oh, wait, right at the very bottom, the second bold box, right under Carlos Lamont. Oh, yes. And could you read that name, please? Falta Ellis. Do you know anyone named Falta Ellis? No. Oh my God. Okay, hold on a second, guys. No, she doesn't know who Falta Ellis is. And do you see there's a phone number to the right of that? Yes. Ending in 5653. Yes. Is that a phone number you're familiar with at all? No. Okay. I also want to move back to the beginning of that box. Do you see there's a line that says current employment type? Yes. What's listed there? I heart host Steve Harvey. Is that how you would have described your current employment title? No, no. How would you describe it if someone asked you what your title is? How would you describe it? I would say co-host of the Steve Harvey Morning Show. I would say that. All right, I'm going to flip now to page 4 of the document, and we'll see at the top it says joint credit intention signature. Yes. Okay. Do you see about halfway down that document there's a line that says credit application signature? Yes. Do you see under that line there's a box that says your name, Shirley Strawberry? Yes. Do you see what appears to be a signature above that? Yes. Is that your signature? No. Did you authorize anyone to sign this document for you? No. And before this issue came up in court, did you have any knowledge that your signature had been used on this application? No. Now, going down just a little bit, there's another line that says marketing consent. Do you see that? Yes. And do you see there's another, what appears to be a signature is your name? Yes. Did you sign that? No. Did you authorize anyone to sign your name? No. All right, now I'm going to flip a few more pages ahead. Do you see a retail installment contract and security agreement at the very top? Let me know when you're on that page, please. Okay, now if you'll flip 2 more times from there, and do you see another page appears to have a signature and your name on it? Yes. Did you sign this page? No. Did you authorize anyone to sign this page on your behalf? No. And could you flip to the very last page for me, please? Yes. And do you see at the top right side of the very last page that appears to be another signature in your name? Yes. Did you sign there? No. Did you authorize anyone else to sign on your behalf? No. And then moving down this page on the left side, do you see another signature that appears to be your name? Yes. Did you sign that one? No. And did you authorize anyone to sign that one on your behalf? No. And do you see to the right of the bottom signature, there's another what appears to be a signature in your name of Desiree Torres? Yes. Are you familiar with anyone by that name? No. Now, Ms. Strawberry, you testified that today is the first time you're seeing this document. Yes. When did you first become aware of the existence of the F-350? Not your involvement in it, but just that the defendant had become to own this Ford F-350. That had to be, well, I'm not sure, but I'll say 2020 or 2019, somewhere around there. 2019 maybe, or 2020 maybe. Do you have any reason to believe that you wouldn't have known about it pretty soon after he purchased the vehicle? No. Okay. And when do you remember him purchasing the vehicle? Yes. And did you have any idea at the time, really anything about the purchase of the vehicle other than it was being purchased? No. When did you become aware, or did you at some point prior to today become aware that the vehicle had been registered in your name? Well, it was after, I guess, that he got put in jail and I had to start paying the payment when I realized it was in my name. I didn't know it was in my name. And so when you refer to paying the payments, are you talking about just the monthly car note on the vehicle? Yes, the monthly car note. Yes. About how much do you pay on the car note? $899 and some change. $899 and some change each month. Yes. And are you still making payments? Yes. And even though this vehicle was purchased in your name without your knowledge, why did you decide to make these payments? Why did you decide to make these payments? Keep making these payments because it was in my name and I didn't want my credit to go bad or whatever because it was in my name and I had to pay it. At the time the vehicle was purchased, did you know Mr. Williams was married to more than one person? No. And had you known that Mr. Williams was married to more than one person, would you have married him? No. And had you known that Mr. Williams was married to more than one person, would you have authorized him to purchase a vehicle using your personal information? No. Mr. Wooten, I have no further questions. Thank you, Miss Strawberry. Miss Strawberry says you're welcome. The court states, Mr. Hoover, yes, Your Honor. Thank you. This is the cross-examination. Good morning, Miss Strawberry. And she says, good morning. My name is Sean Hoover, and I have a couple of questions for you. So for starters, it was your testimony just now that you started paying or that you realized you started paying for the truck yourself once Mr. Williams was arrested. Is that true? I started paying for it, yes. Once he was arrested, yes. So just so we have a better idea what you actually mean by that, did you apply like your bank account to a system so that money could come out of your bank account? No. Okay, did you go to a place where the vehicle was purchased and say, hey, I'm going to start taking over payments. Here's all my information? No. So between the first time it was purchased up until, like you said, Mr. Williams got arrested and you started paying for it, did you change any of the account information so it was personally coming from you and not from Mr. Williams? I did change. I did. Did I change any of the account information? Yes, ma'am. She says no. Okay, between the first time that the vehicle was actually purchased up until where you claim you finally realized about it when he was arrested, did you change the account information on the insurance of the vehicle? The insurance information, well, no, I didn't change the insurance information, I don't think. And I'm having to think about this, but I did have to include it in my insurance so I could pay for it. Yes, ma'am. I hope that answered the question. It did. It did. It just for clarification purpose, the account that the money was coming out of to purchase the vehicle never changed between the first day it was purchased up to where you claimed that you started paying for it yourself. The account never changed, correct? Well, I can't say that for sure. I can't say that for sure. I just started paying it out of my personal account. Yes. And I never did that before. So is it your testimony? Well, let me ask you this. The account, the first account that was used, the first bank account that was used to open this vehicle, to purchase this vehicle, was that the personal account you continued to make payments out of? I don't know anything about that. The account that the payments were made from, all I know is I paid it out of my account once he was arrested. Yes, ma'am. And as you testified before, you didn't go to the company where he purchased the vehicle and say, hey, put this in my personal account so I can start paying for it. I just want to say, who does that? You didn't do that? No. Okay. The same for the insurance. You didn't go to the insurance company and say, hey, put this in my personal account so I can start paying for it. You didn't do that? Who does that? Aren't they the stupidest questions in the world? Dumb. Girl. No, but this is not, he's asking like this is damn Little House on the Prairie and you got to go run to it. First of all, no, sir. No, it doesn't work like that in 2025. CW, thank you guys for gifting some memberships. You guys are so sweet. Thank you, CW. Thank you, Acme. I appreciate y'all very much. Thank you for supporting. I'll roll back when we're done. We got quite a ways to go. We're on page 24 and we got 117, y'all. So bear with me. But thank you guys for gifting. You guys are very sweet. I appreciate y'all supporting. Okay, dumb questions. Yes, Hoover, dumb. Okay. And thank you, by the way, for appealing so we could get this nice transcript of the event because a certain blogger had a temper tantrum and now we get to really fully understand temper tantrum free. Okay. Okay. Thank you for supporting this channel. Okay. All right, let's get back to it. Hey, something is wrong with him. Something is, oh, you're welcome. You're welcome. Okay, let's get back to it. And welcome to all our friends on Facebook, Kiva, Kat, and Beverly. Thank you for tapping in, booze. I appreciate y'all. Fat Thighs Hoover, how you make Nesto think you was really trying to defend him. Hoover, girl. Hoover must not really know how transactions work if you actually have a real bank account. He's operating, and God bless, but there are people who still run payments to the, you know what I'm saying? Like I'm talking to somebody right now, and God bless you. But there are people who are running payments to the buy here, pay here lot. There are people who are running over to their insurance office and dropping off a payment. There are people who are going to pay at the rental office. You know what I'm saying with them? You know what I'm saying? Like there are people who still are personalizing their payments and not doing everything electronically. We have to realize that there are people who still do this, but at the end of the day, I think Hoover, I don't know how, maybe based on Hoover's conversations with Nesto, he approached it in that way to Shirley. But this is a lady who makes quite a hefty salary. And even though she has had her share of financial problems, I don't see her running around town to pay bills on payday. I think my assumption would be she has an adequate, at least a debit card to make said payments and not have to go run around and pay things and run to this office and run to that office to go pay things in person, I would imagine, but I could be wrong. But that's what it's giving, the way he's asking those questions, that somebody is actually going to each individual place to make these payments. And who really does that? Even though, everybody doesn't do that. Okay. I'm gonna say it like that. Victim blame and victim shame. Okay. Baby, yes, especially around tax time. You always hear about someone getting clunked over the head and they had about $3,000, $4,000, $5,000. They were over to Walmart and someone got them straightened out in the parking lot. Absolutely. And it's awful. Yes, absolutely awful. Anyway, okay. Absolutely. Yes, ma'am. And shoot, quiet as it's kept. I mean, I'll go to the ATM and get some cash because I like to have a little bit of cash. It's a flex to have some cash available, right? Because baby, when you go to the store and the machines are down in that rare occurrence and you got you got a 50 or 100, you should at least have a 50 or 100 stuffed in your bag, because the worst is going to the store and there's a problem with the machines, and the only thing they can take is cash, and you don't have any. So anywho, let's get back to the text. Okay. And for the insurance, you didn't go to the insurance company and say, hey, put this on my personal account so I can start paying for it. You didn't do that? No, they asked me to pay for it. The insurance company did. So you testified that you continued to make payments on it because you didn't want to affect your credit, correct? Yes. So at this point, were you claim you realize that the money is now coming out of your account, did you ever go to the company and say, hey, I want to return this vehicle? I didn't want to purchase this in the first place. Yes. I mean, I didn't go to the company because it's a company out of Los Angeles. But yes, of course, I didn't want to do that. I didn't know it was in my name. It was a surprise. Once I found out it was in my name, I had to pay for it. Yes. Yes, ma'am. I understand that you said you started paying for it. I feel like he purposefully asked weirdly worded questions. I don't know if he was trying to confuse Shirley on purpose. I don't know if he's trying to confuse the record, but I feel that in just my gut, I just feel like he was asking very bizarrely worded questions for somebody who makes in excess of $500,000 a year. This man is an attorney. He's asking her questions of payment practices that are not the norm anymore, even for someone who could potentially be unbanked. He's asking the questions really weird, and I feel like he's purposefully trying to ask things in a strange, bizarre way, because it just doesn't make any sense. It makes you feel like he doesn't know anything about how people currently bank or pay for, like, do their monthly accounting. And like this scenario of, hey, I don't want to pay this anymore. Like who, if that's really the case, who actually even does it like that, right? It's just weird. I just felt like he had a very unsophisticated knowledge base, or was coming from a very unsophisticated place of asking Miss Strawberry how she would go about transferring payment while her husband was incarcerated. At the end of the day, his bills, even before Shirley found out that Nesto was married to somebody else, if your husband is incapacitated via whatever the situation is, he could have bumped his head and been in the mental health clinic. He could have been hospitalized. He could have had a stroke or an aneurysm, right? You're trying to pay this man's bills, right? Initially, when Shirley took over the payments, it wasn't because they were splitting up. It was because he was incapacitated to a certain degree, right? There's no difference had he had a traumatic brain injury or a heart attack. He's indisposed. He's not available. And you now, as a wife, are picking up your husband's bills, right? I guess Shirley didn't say that, but he also didn't ask it that way. You know what I mean? So it was just weird to me the way he asked the questions, because at the moment, she's still thinking her husband's getting out of jail, and she's just picking up the slack of paying his bills and also finding out, oh shit, this is actually in my name, according to her, right? So, girl, isn't it just unbelievable? Even people who are quote unquote unbanked have debit cards now. Cash App has made it easier for people who don't have traditional banking relationships to be able to digitally pay their bills. Nobody is really running back and forth. But yes, there are probably a very small population of people who are still doing that, but it's even less because people have PayPal, Zelle, there's all the Cash App, there's all different types of payment methods where you can have a debit card and not have a traditional banking relationship and kind of have, whatever. We all know this, right? Okay. Hoover obviously does not, but we do. It's awful. I think he was also trying to screw the record. Lawyers will ask simple questions, making sure the client understands. Yeah, it was weird the way he asked those questions. Anyway, okay, let's keep going, guys. It was a surprise. Once I found out it was in my name, I had to pay for it. Yes. Yes, ma'am. I understand that you said you started paying for it, but my specific question was once you're saying that you found out that it was in your name. Did you ever go to that company where the vehicle was purchased and say, I don't want this vehicle. I didn't not purchase it. Why would she do that if she thought her husband was getting out of jail next week? They could have just sorted it out when he got home. I think in his brain, he's thinking about them being divorced, them not being together. But at the moment that she found out in July, August, September, whenever it was that the car was in repossession, he put the vehicle in her name and she was going to have to start paying for it. They were not broken up at that time. So why would she call and say, I don't want the car when that's the car her husband drives? Even when she really said she didn't want it after her Mercedes got seized, he talked her into keeping it because he said he was getting out soon and he wanted to be able to drive it. Right? So, I mean, obviously, Hoover doesn't go here and he doesn't know what we know because we know his client better than he does. But I digress. Okay. The way I saw Nesto walk out of the store and not pay for the coffee, that man would do anything. Girl, I'll be back. I'll pay for the coffee later. Now, the only way you get free coffee at a gas station, and I'm talking about like Quick Trip and things like that, you got to come with your own mug or your own coffee container. And I think you get free drinks at some of the bigger establishments. You can get ice water. You got to come with your own cup and they'll let you fill up. Anyway. Okay. Did you ever go to the company where the vehicle was purchased and say, I don't want this vehicle. I do not want to purchase it? I didn't go to them, no, because they're in Los Angeles. But I did have phone conversations with them, yes. Can you without giving us hearsay? So you told them that you did not want the vehicle anymore because you didn't pay for it? Maybe not in those exact words, but I did say, why am I responsible for paying for this car? Well, because your husband put it in your name. That's why. And when you were divorced, you didn't then say, Your Honor, this isn't my vehicle. I have nothing to do with it. Get rid of it. You didn't tell the judge in your divorce hearing that, did you? No, it didn't come up. So can you explain to this court what step did you take to get this vehicle that you never knew anything about out of your name and off your account? Well, I had a conversation with the finance company, Westlake Financial. I believe I believe it is. And I told them the circumstances of I didn't know this truck was in my name. Why do I still have to pay for it? And they said, because of that, it's in your name. And basically that was it. When did you have a conversation with Westlake Financial? It was about 2022, I think. About 2022. So if I heard you correctly, you found out about the vehicle in 2019 or 2020, correct? Yes, that he had purchased the vehicle. Yeah, it was his vehicle. Yes. And the first time you said anything about that you didn't want it in your name was to Westlake in 2022. Yes. And did you ever go to the district attorney's office in 2022, between 2022 and today, and say, look, these are the steps I took with Westlake Financial to get this out of my name? Absolutely not. I did not know that I could do that. But now that I know that I can do that. Well, so he's also kind of intimating that she should have maybe filed identity theft charges against him, because that's exactly what ended up happening. So you're saying that when she found out that Ernesto had the vehicle in her name and they fell out once and for all, that she should have filed identity theft charges against him for using her name without her permission. Well, guess what, Hoover? Your client just got another case, okay? Because of all of your brilliant questioning, you fooled around and got your client 2 new cases, okay? Because that's exactly what happened, all right? Will Wooten was probably sitting there thinking, and that's exactly what I'm going to do, okay? Thank you for bringing that up, because that was something that we forgot to do in the RICO. We're going to just add those, the strawberry indictment and the PGR. Let's see what else we forgot to charge him with, so we can just go ahead and add those on, okay? Since you want to be cute and ask foolish questions. Okay. That conversation that we're just now hearing about from 2022 and Westlake Financial, did you ever go to Officer Fields or any other law enforcement officer and say, look, these are the steps I'm taking to get this vehicle out of my name? No, I didn't do that. I did discuss it with them, though. Which officer? I don't know. I don't know which one now at this moment, but yes, I did ask them about the vehicle. Do I still have to pay for it? Do you remember if it was a male or a female? Maybe a male, yeah. Do you remember around what time of year it was? No, I don't. Miss Strawberry, yes. At the time that I guess all of this was going on with the vehicle, how many different residences did you have with Mr. Williams? The vehicle, just one. Which residence was that? Bent Creek Manor. And how was, let me back up and ask you this. Did you sign the paperwork for Bent Creek Manor? No. Okay, who did that? He did. Mr. Williams? Mr. Williams, yes. And the money that was being paid for Bent Creek Manor, whose account was that coming out of? Mr. Williams? Question, Mr. Williams, the houses on Pine Grove, did you have anything to do with those houses? I'm not familiar with the house on Pine Grove Road. I didn't live there. Question, thank you. And I guess my last question about the vehicle, is it your testimony today that you didn't set up insurance, with your license and information to get insurance on the vehicle that day? Gosh. Yeah, exactly. What day? The day the Ford was actually purchased. Yes, that is my testimony. I did not do that. Now, correct me if I'm wrong. When you were speaking with the state just a while ago, you said that you realized later on that Mr. Williams was married to other people. Is that correct? I may have said that. I was told that. Oh, yeah. Okay, not that I realized it. So that was your question. Is there anything that you can show this court today that says, look, this is how I can tell or prove to that Mr. Williams, I know that Mr. Williams was married to multiple people during that time? That I can't, that I can today. I can talk to my divorce attorney and find out, but other than that, no. And we're gonna talk about her in a second, but just for now, your testimony is there's nothing that you can show the court yourself to say this was how I personally know Mr. Williams was married to multiple people. No, it's just that other people told you. That's what my lawyer told me. Yes. Now, your divorce attorney, when you were in the hearing to finalize everything, you didn't get an annulment, did you? No. You got an actual divorce. Is that correct? Yes. And did your divorce attorney tell you the difference between an annulment and a divorce, what a divorce actually means? No. Did my divorce attorney tell me that? Yes. No. So the person who represented you in your divorce also told you Mr. Williams was married to multiple people, didn't explain to you the difference between an annulment and Your Honor, objection. This is getting into privilege, attorney-client privilege substance. Well, it's not when, I'm sorry, Mr. Hoover. Well, it's not when you're specifically addressing his bigamy issue, and the state brought it up. Now we know the only information that she knows that this witness knows about is from her attorney. So I can ask a specific question. To we're not going into major detail. This is a specific question based off of information that she's already provided that the state literally walked in. Well, I think you asked and she answered that she got the information from her lawyer. So if there's another question, I'll sustain and asked and answered objection, and you may ask another question. Thank you. I have that answer. So no further questions right now. Okay. Thank you. No redirect, Judge. She may be excused. I want to make sure I understand. So before she steps down, the witness can testify versus her lawyer testifying. Ms. Strawberry, the truck that you've been questioned about, is that the truck currently registered in your name? Yes. Yes, Your Honor. When did you get it registered in your name? Registered in my name? Yes. I mean, you know what? Let me say this. The truck, I haven't driven it for years, or I don't drive it, but I don't know when it was registered in my name. I don't know. I assume when it was purchased. I don't know that answer. I'm sorry. Okay. All right. But you currently, now that the registration is in your name. Yes. But you don't know when it was first registered in your name. No, I do not. All right. Okay. That's what I had. Anything else? So, I mean, to me, the identity theft was from start to finish. He used her credit. He bought the vehicle. He probably called the insurance company that they were already using for insurance and just added it like anybody else would. If my husband were to buy a car today, he could call our insurance company and add it to our portfolio of cars. Like at the end of the day, that's not a mystery. Like if you do business together as a couple, somebody can if you have your cars on a family plan, you can add cars. So I don't think that's out of the ordinary. But to me, when he asked her, did she register it? And she knows she actually never registered it and it's been registered. So not only did he purchase it, he used her credit, he purchased it and insured it and also registered. So used her credit, actually purchased transaction, insured it, and registered it with the state. All of those things without her permission or without her knowledge. She later found out that this happened, but she wasn't really pressed about it because that was her husband and she was under the impression he was coming home. So she wasn't trying to put identity theft charges on him because that was her husband. So she was paying his bills because he's incapacitated, right? Now that they're not together anymore, thus the strawberry indictment. Now he got some more charges. Okay. All right. Redirect examination by Mr. Wooten. Miss Strawberry, when you were divorced, was there a trial like where witnesses came and testified? No. And did Mr. Williams contest the divorce or was it uncontested? It was uncontested. I have no further questions for the defense attorney. I have no further, the court, for the defense, Attorney Hoover. No questions, Your Honor. All right. May the witness step down and be excused? Yes, Judge, please. Thank you for coming. Thank you. Judge, the state calls Investigator Ansel. Okay, state your name and spell it. Billy Ansel, having first duly sworn, was examined and testified as followed. Mr. Wooten and Investigator Ansel, where are you employed? Fulton County District Attorney's Office. Okay, before we get into Mr. Ansel, are there anything I need to read? I wonder what happened to the other cars he had, such as the yellow Hummer. I wonder if those were gone by then. Those cars, I wonder if the cars were gone because he was driving the Mulsanne. He had the F-350. He flipped them because I feel like he went through lots of cars. It probably got either repoed, flipped it, something. Good question, Janetta. I'm not sure. Right. They were all part of the Nesto fleet. I wish she had said, girl, those Zooms were hilarious. So we had a couple of them. I think there was one or two. The last one we were not able to film. The judge Hoover came and poo-pooed the whole thing and we couldn't show it. But if you're in members, if you hadn't seen, some of that is actually in members, but the last hearing we were not able to film. So what's available I think is in members. Some of it might be over like in just a live stream of that day. I don't know. I'll have to bubble up. I'll bubble up whatever we have. If anyone's new here and hasn't seen any of the divorce stuff from last year, it's in there. It's in the playlist. So you just have to scroll back to like summer of 24. That's when all of the divorce stuff was going down. Okay, let's get into Detective Ansel. Guys, we're going to go as far as we can, and then we can finish it up tomorrow. But let's just keep going because we're only on page 35, and I got to cook dinner like in the next, let's just say I got a good hour and a half. So we'll keep going. You never know how far we'll get, but we'll do as much as we can. Okay, so Detective Ansel is now on testifying. And Detective Ansel is stating that he works for Fulton County District Attorney's Office. Now, I'm going to be on when Miss Ma'am had her temper tantrum, the blogger that was in the court who did record some of this, I didn't bother to watch any of this stuff. The way it was broken up and all of the inaudible whatever nonsense, this is all new to me, so maybe some of this might be new to you. I watched some of the Shirley testimony and that was it. I had to drop off because it was too much foolishness going on. So I'm happy that we got a chance to actually now understand what happened during this proceeding. Y'all, is that Amazon? Okay, good. Thank you for quiet delivery. Y'all, You know how sometimes Amazon comes and then they ring the bell, and with having 2 dogs, baby, please do not ring this bell unless you really want us to come open up the door, don't do that. Um, I couldn't do it. It was too much. It was giving me anxiety. Yeah, it was too much. Okay, let's get into it. All right, so Detective Ansel says he works, or I think it's a gentleman, works at the Fulton County Court District Attorney's Office. And what do you do at the District Attorney's Office? I primarily investigate white collar crime. Did you have the occasion to become involved in the investigation of this case, the state versus Ernest Williams? I have. And can you just briefly summarize what you've done as part of the investigation in the general nature? Following up on records, subpoenaing documents that were given to me by the investigating agency. Judge, may I approach the witness? Yes. Investigator Ansel, I'm showing you what's been marked as State's Exhibit 1. Are you familiar with that document? He said intimately. How did you become with this document? I requested the financial document from Westlake Financial. And what caused you to request this document? The vehicle was seized, and I wanted to see all of the information that was pertaining to that vehicle. And so when you say the vehicle was seized, which vehicle are you referring to? The Ford F-150, Ford 150, or 350. 350, I'm sorry. Okay. And so the document that I'm showing you, I'm going to just ask you a few questions as it relates to it, some of the information that's on the document. So if you see on page 1, there's a bold box that says credit application, applicant. I do. And do you see in there's a line that says preferred email? I do. And what is the email address? All right, let me go past that. Hold on. I don't know whose email address that is at yahoo.com. And does the name Ruby Laura have any significance here? Okay, so that might be the actual Laura's trucks. It does. It does. What is that? It's the secret, and I did a Secretary of State search for people with that name and finding out which businesses they were. Her name came up as the business partner in a different automotive business as the principal owner at Laura's Trucks. Okay. And as it relates to this document, what is Laura's Trucks? Laura's Trucks is the dealership in which Mr. Williams purchased the vehicle. Laura's Truck is the dealership in which Mr. Williams purchased the vehicle. Okay, just so I'm clear, you're saying that Ruby Laura is a partner with the owner of Laura's Trucks and some other company. The Secretary of State or a signatory based on the Secretary of State's website. Okay, I want to move down to the line. Do you see the lines that say home phone or mobile phone? All right, girl. I do. And do you see a phone number there ending in 2629? I do. Were you able to make a determination as to whose number that is? According to law enforcement databases, it comes back as Alicia Alexander. And is Alicia Alexander, someone who is familiar to be related to this investigation? Yes. And how is she familiar to you? She goes by a different name further in the investigation and in other cases. What is that name? Dominique. And I know Nesto must have been sitting in his seat like, oh shit. Okay. Dominique. And to your knowledge, Does Dominique or Alicia Alexander have any type of relationship with Ernest Williams? Bingo. Yes. Can you give us some information about what that relationship is or how she has come up? She has come up with Mr. Williams when it comes to sort of like a secretary or a servant in the type of role of a subservient role. Okay. Like maybe an assistant. Right. Like I said, yeah. All right, so I want to move down to the next large bowl box towards the bottom. There is a name listed, Carlos Lamont. Are you familiar with anyone named Carlos Lamont? No. Okay, as it pertains to Mr. Williams, are you familiar with anyone named Lamont? Mr. Earl Dunbar Lamont? Okay, and who would that be? One of Mr. Williams' longtime friends and associates. Under the name Carlos Lamont, do you see there's a line for a phone number? I do. And what is that number ending in 0141? Whose phone number is that? Earl Lamont Dunbar. And do you know if Mr. Williams has spoken to Mr. Lamont at the phone number listed here? I do. Hold on a second. I do. And how do you know that? Jail recordings. I have that number listed as an incoming phone number. And have you actually listened to any of the phone calls where Mr. Williams has spoken to Earl Lamont Dunbar at that phone number? I have. Do you remember? And if the answer is no, that's okay. But do you remember if were there any phone conversations that stood out to you in any way? Let me tell you something. If Nesto hadn't stopped talking about his phone calls, him and Sonia really have stopped talking about, I mean, they haven't talked about the case in a long time, but since he went to court and sat there, baby, he hasn't really said much in the past 2 months at all. He's not talking about nothing. Like he says, I'm not talking about nothing. If he didn't, I mean, so he sat there 20 feet away from someone basically like, I know the phone number. Alasia is Dominique. Earl Lamont Dunbar. Oh, yeah, we've listened to his calls. We know all of this. And so does everybody else because everybody else has heard it too, the whole internet. Okay. That's okay. Do you remember if were there any phone conversations that stood out to you in any way? They ramble back and forth a lot about finances and shoes and glasses. There was one phone call, for instance, where the name is familiar, but it doesn't jump out as to be a reason. Okay, based on the phone calls that you've listened to, and would you categorize their relationship as close friends? Oh, most definitely. So moving down underneath Carlos Lamont line, do you see there's another name listed? There, Falta Ellis. I don't know what's coming up next, so let me take it off the screen. Falta Ellis, I do. And do you see to the right of that, there's a phone number ending in 5653? Yes. Were you able to determine anything about who owns that phone number? I was. Were you able to determine anything about who owns that phone number? I was. And who owns that phone number? A young lady by the name of Faye Ellis. And did you speak with Faye Ellis? I did. What did she tell you as it relates to the name and number appearing on the document? She does not know Shirley Strawberry. She does not know Ernest Williams, but she said her daughter might know Ernest Williams. And did she say anything about who all has had access to her phone number? her daughter, and anybody else that was in the family that would have given it out. Did she, so to be clear, did she say that her daughter had used her phone number before? Yes. Did you have an opportunity to speak with Shirley Strawberry about this application? Yes. What did she tell you as it relates to whatever or not she ever authorized this or signed this? She said she did not authorize any signatory or any of her signatures to be utilized on this. She doesn't know any of the principles in the information given, and that to the best of her knowledge, Mr. Williams owned the vehicle. Your Honor, may I approach the witness? Yes, I'm going to hand you what's marked. In fact, I'm going to hand you what's marked as State's Exhibit 2. Are you familiar with State's Exhibit 2? And what is State's Exhibit 2? It's a marriage certificate from Aiken, South Carolina. And who is this marriage certificate? Who is the husband and wife? Ernest Lavert Williams Jr. and Edith Wynn Miller. When does this marriage certificate show the two of these individuals were married? October 22nd. It was just Nesto's wedding anniversary. Oh my God. Wow. Nesto been married 40 years, y'all. October 22nd, 1985. Nesto been married 40 ball, y'all. Nesto been married 40 years. Baby. Okay. And do you know where this document came from? I want to say it came certified from Aiken, South Carolina courthouse. Okay. Did you attempt to see if you can make a determination as to whether Mr. Williams and Edith were ever divorced? I was unable to find a record of that. So to your knowledge, it's unclear. There's no indication that they were ever divorced. Not that I could, not that I was provided. Judge, may I approach the witness? Okay, I'm going to hand you what is marked as State's Exhibit 3. Are you familiar with State's Exhibit 3? What is that? A certified copy of Mr. See, there's a reason why a certain blogger didn't want the people seeing or hearing this testimony, because that person has a vested interest in a relationship with the defendant and the defendant's side chick. So there's a reason why the blogger, the one person who had a camera, wanted a very screwy record, and that we weren't going to be able to hear this information because, baby, it's not cute. Okay, State's Exhibit 3 is a certified copy of the marriage application of Ernest Williams Jr. and Martha Jean Halliburton, a marriage license for the same individual and a marriage certificate for the same individuals. And what jurisdiction is this marriage out of? DeKalb County, Georgia. And looking at the first page of the application for the marriage, do you see a date at the bottom of the application? Was signed and filed? Looks like September 1st, 2001 on the very last line. Actually looks like, what does that say on the right? Excuse me, to the left of that, date and place of contemplated marriage. Okay. And then do you see beneath that a line where another date where it appears that the application was submitted above the clerk's signature? Right. I'm trying to get the year. That 20th of August, 2001. Okay. And on the marriage license application, do you see a column to the left side? Each of those rows are numbered. I know it's small. Do you see a row numbered 7A? I do. And what is the description for the row 7A? number of previous marriages. Under the column for Mr. Williams, what number of previous marriages did Mr. Williams list on his application? 0. Do you see going down? There's a row 8, yes. And what is row 8 described as? Any legal impediment? What did Mr. Williams indicate as to whether there were any legal impediments to becoming married? He said no. And do you see going all the way down beneath? Do you see there's a box outlined and going right beneath what there's a certification? The faded? I can skip that. I'll withdraw that question. So can you flip to page 3 for me of this exhibit? Yes, sir. And what's page 3? State of Georgia marriage certificate from the county of DeKalb. And what does it show? What's the date that shows that Earnest Williams and Martha Halliburton were married? First day of September 1st. Judge, may I approach the witness? Okay. I'm going to hand you what's marked as State's Exhibit 4. Are you familiar with State's Exhibit 4? Yes, I am. What's State's Exhibit 4? It's a marriage license for Ernest L. Williams Jr. and Shirley Ann Clark Strawberry, as well as a marriage certificate for the same individuals. Okay. And did you personally obtain these documents? I did. Where did you get it from? Fulton County Probate Court. Okay. So can you see going all the way down to the bottom on the right above the clerk's signature? When was this application made? 16th day of December 2014. And going to, you see all this one, like the previous one, had number rows. Do you see that? Yes, sir. And do you see row 7? Yes, sir. What does it say on row 7 described as number of previous marriages? What was Mr. Williams? Does Mr. Williams list there? 3. Do you see row 8? I do. And what does row 8 say? How was each marriage dissolved? He said divorce, annulment, or death. What did Mr. Williams indicate for his answer? He said divorced. So he said he had 3 previous marriages and all of them ended in divorce. And then do you see number 9? I do. And what is that one described as? Date and place of each dissolved. Date and USC and state or foreign country. And can you see what Mr. Williams indicated as the dates and locations where each of those were dissolved? I do, and to the best I can reading it, South Carolina, 1988. Atlanta, Georgia, 1994. And Decatur, 2010. And then Georgia. And just to be clear, that last one, does it appear that Decatur 2010? Yes. And that all goes together. Yes. And then row 10, what is row 10 described as? Any legal impediment reason you should not be married. And what did Mr. Williams indicate for row number 10? No. And turning to the next page, what is on the next page? Marriage certification for the state of Georgia, county of Fulton. And what is the husband and wife listed? This is certified that that Ernest L. Williams and Shirley Clark Strawberry were united in marriage. And that's the date, the 9th day of January, 2015. Your Honor, may I approach the witness? Yes, I'm showing you now what's been marked as State's Exhibit 5. Are you familiar with State's Exhibit 5? I am. And what is State's Exhibit 5? It's a final decree from Superior Court of Cobb County, state of Georgia. And who are the husband and wife listed? on that decree. The plaintiff is Martha Halliburton and Ernest Williams, defendant. And do you see the date on this decree was made final? That the divorce was made final? The decree was entered the 29th day of 2021. My Lord. This is so embarrassing. And what justification is the divorce, and what jurisdiction is this divorce out of? Cobb County. And so, do you remember on the previous exhibit, you just listed the date and place each prior marriage was dissolved? Yes. Did the defendant, I'll withdraw that question. Oh, Wooten is so messy. Yeah, we know. Okay. We already know. I mean, the receipts say it themselves. And that was exhibit 5, the court's exhibit 5, the state. Yes, 5, Your Honor. I promise I'm almost done, Judge. But may I approach the witness? Yes, sir. I'll give them to you at the same time. I'm handing States Exhibit 6 and 7. Yes, sir. Are you familiar with States Exhibit 6 and 7? See, baby, Nesto hasn't been talking at all because he literally got his ass chewed last time he was in court. I mean, we didn't get to really see it because there was a saboteur with a Rule 22 who really didn't want us to hear what was actually happening. But baby, we got this. We have the transcript now, so we actually know what's going on here. Okay. Are you familiar with States Exhibit 6 and 7? I am. Okay, what is Exhibit 6? It's the petition for the dissolution of marriage between Shirley Strawberry and Ernest Williams. And what jurisdiction was that divorce petitioned in? Fulton County. And do you see at the top right where the filing date? I do. It was the complaint filed April 17th, 2024. And then moving to States Exhibit 7, what is the final judgment and decree of divorce between Shirley Strawberry, petitioner, and Ernest L. Williams, respondent? And the same question, do you see at the top right, there is a date for the final decree filed, September 30th, 2024. And I'm going to ask you to turn to page 2 of the final divorce decree. And do you see that the paragraphs are numbered? Yes. Do you see the paragraph number 6? I do. And could you read number 6, please? The respondent did not file an answer or otherwise respond to the petitioner's complaint. The court set the final hearing for September 25th, upon which the respondent appeared and stated he did not object to the divorce. And I'll just say, as somebody who was a witness on the Zoom, yeah, he didn't have any questions. He did not contest anything. He did not claim anything. He barely spoke. Okay. One moment, Your Honor. I have no further questions. The court. Attorney Hoover, anything on cross? Yes, Your Honor, briefly. This is the cross-examination by Mr. Hoover. Question. Good afternoon, investigator. Good afternoon, Mr. Hoover. A couple of questions for you. Okay. In regards to the marriage certificate that states, I didn't get the number, but I believe the state of South Carolina. Do you have that in front of you, or did they take it back? He took it back. Mr. Hoover, you can use them. I'm sorry. Whereupon the document given to Mr. Hoover. I'm now approaching you with States Exhibit 1, 2, 3, 4, and 5. I am in receipt of 1, 2, 3, 4, and 5. So the one specifically dealing with South Carolina, do you have any evidence to give to this judge that the marriage was not actually dissolved in any one way or another? No. Do you have any evidence whatsoever that you could say, I know for the fact that Mr. Williams is still married to the woman from South Carolina? Call her on the phone. No. Okay, so States 3, the marriage application and certificate between Mr. Williams and Miss Halliburton? Do you have any evidence to show this judge that the actual marriage was dissolved because he was still married to someone else? No. Do you have any evidence whatsoever that Mr. Williams and Miss Halliburton were not actually divorced at any time, or that they're still actually together? You're going to have to rephrase that one. I apologize. Do you have any evidence to show this court today that Mr. Williams and Miss Halliburton are still technically or legally married? No. Okay, now in regards to the marriage of Mr. Williams and Miss Strawberry, yes. Do you have no evidence to show this court that marriage was dissolved or basically voided because he was married to someone else? Do you? Answer. Hold that thought, Mr. Hoover. Yes. The answer to your question would be no. Thank you. And again, you never got any information that marriage was annulled, correct? Annulled as to the word itself? No. Okay, now let me make sure I get the date correct. Mr. Williams was arrested July 7, 2022. Does that correct? Hold on. Does that correct? Does that sound about right to you? I'll go with your rendition. On July 7th, 2022, did you come across any information that law enforcement had that showed that he was still married to the lady in South Carolina? Can you rephrase your question for me? Yes. When Mr. Williams was arrested on this date, did you come across any information that anyone in law enforcement had evidence that he was married to a lady in South Carolina on the date of his arrest? Yes. No. Okay. The day Mr. Williams was arrested, did you come across any information that any law enforcement had evidence that he was still married to Miss Halliburton? No. Now, the mortgage company for the Ford, he says mortgage company, but it's crazy. The mortgage company for the Ford, I guess Westlake Financial, that may not be in Georgia, but the actual physical location where the vehicle was purchased, that was in Georgia at one point, correct? The mortgage company? No, sir. No, the actual physical place where the vehicle was purchased, right. You use the term mortgage and that's not what it is. Thank you, somebody, for finally correcting him. I'll break that question down. So the mortgage company itself, I don't know. Hoover doesn't seem to have basic financial knowledge, you guys. It's very strange. He doesn't seem to know that mortgage companies finance real estate. And he's talking about vehicle financing. So it's very weird. He wants to keep using mortgage company, but mortgages are on real estate, property, houses, things of that nature. Right. You use the term mortgage and that's not what it is. I'll break the question down. So the mortgage company itself, Westlake Financial, which is not a mortgage company, Westlake was not actually in Georgia. Is that correct? There's not a mortgage company, to my knowledge, named Westlake Financial. I'm so glad he stuck with that. The physical location where the vehicle was purchased through was in Georgia. Is that correct? Yes. Okay. Did you receive any information based off of when law enforcement did its investigation that one of them had evidence that they went to a physical location and they have evidence that Mr. Williams go this by fraud the day he was arrested? No. Do you or anyone else in the district attorney's office ever go to a physical location to get a surveillance video? What physical location? the physical location where the truck was purchased, did you or anyone else from the DA's office ever go to try to receive surveillance video? You're assuming that there was a surveillance video. I have never been to that location. Whether a video was there or not would be news to me. So you have never been to the location yourself, correct? And did you receive any information that anyone from law enforcement went there to try to get a surveillance video? No. Okay. Did you receive any information that anyone from the district attorney's office tried to go to the location to get a surveillance video? Mr. Wooten, Judge, I'm going to object on this, is calling for relying on facts, not in evidence. There has been no establishment that there is a video. So the question saying, did you ever go to the video, are improper. It's relying on the fact that there was not, that has not been brought into evidence. I understand, and I understand the question. I'll overrule the objection. You may continue. Thank you, Your Honor. I understand that there's been no video produced, and it sounds like no one has one. Let's be clear. There's no video produced, but there's not even been an attempt to see if the video exists, correct? To see if a video exists, or are you asserting that one does exist? See if a video exists. Okay, yes, thank you. Can you explain one last time about, you said there was someone on some type of document that's one of the state's exhibits that's actually from Lara's trucks. I didn't say she as from Lara's trucks. I said that she is a business partner or on the Secretary of State's documents as a principal of Lara's trucks. Okay, but not involved in Lara's trucks. Is that what you're saying? Through my information with the Secretary of State website, she is not listed as having any business dealings with Lara's trucks. We are talking about the email, right? I believe so. Yes. I just wanted to make sure I heard you correctly. Okay. I just want to make sure I'm answering the right question as well. At this point, no further question, Your Honor. Attorney Wooten, ADA Wooten, anything else? No redirect, Your Honor. All right. Thank you, sir. May the investigator step down and be excused? Yes, please, Judge. No further witnesses on behalf of the state. All right. Would the court want to submit these exhibits to the court reporter? I know they're attached to the pleading, but I just don't know if the exhibit numbers match up. Well, let me have them. You are moving one through whatever into evidence or for the purpose of the hearing. Yes, Judge, 1 through 7. All right, let's have that discussion that I think Attorney Hoover wants to have. State is moving to admit 1 through 7. Any objection? Not now, Your Honor. No objection. Okay, all right. 1 through 7 is admitted for the purposes of this hearing. Does the defense have any questions? At this time, we do not, Your Honor. Okay, so we just have argument. Yes, okay, all right. I need to take a quick courtesy break. We do have ADA Hall back. ADA Hall, anything on your witness? No, Your Honor. Actually, I have come back with additional argument for the purpose of our hearing, so whenever you want to hear that. Okay, let me take a 5-10 minute break, and then we'll come back and hear the argument on both, whereupon a recess was taken. Okay. Woo, baby. Y'all, we're on page 60. If you have not hit the like button, do you go ahead, please? Go ahead, hit the like button for your girl. We have about 519 here. We don't even have 400 thumbs up. I hope that you are being thoroughly entertained and you are getting some information regarding these receipts and all of the things. If you are walking away with a little bit of extra information on today, I'm not trying to hold you. My Lord. Okay. Okay. Hoover is first of all, Hoover doesn't need, this is just my impression while we're taking a little five because I'm trying to sip on some water real quick. Hoover does not need to have anything to do with white collar because he doesn't have any basic finance he doesn't even understand that a mortgage company has nothing to do with vehicle finance. Girl, holding Bazzano down. Girl, could you please stop? Ah! This attorney of a pretty big age and big body doesn't know that a vehicle is not financed through a mortgage company. Now, can you be paying for a car and a mortgage? I guess if you do a debt consolidation and roll it into some sort, you could in theory, but the company would not necessarily be financing your car. You could roll a bunch of debt into a debt consolidation into your house. So it's possible, but he wasn't talking about that. Okay. In all fairness to Hoover and his lack of finance knowledge, it is possible, but that's not typical. And that would be a very specific transaction. But in general, vehicles are not financed through mortgage companies. They're just not. But in the scenario I just mentioned, that could be the case, but that's not the case here. But it's giving lack of knowledge, and that he needs to stay as far away from white collar as possible. Okay. Woo, baby. I can't believe. Okay. How long have we been going? Y'all, we've been going 2 hours. My Lord. Okay. Whew. Okay. Okay. I'm down to my ice. Okay. All right, let's see what's so on page 60. All right, let's see what's going on here. What is the rest of this? All right, let's just try to get through this. We're going to do our best. I think this is now them going back and forth in some arguments. Let's see. I don't know what any of this is about. I didn't see any of this. I'm sorry. All right, we're just going to have to see what we can do. Okay. Okay. Let's go back to page 60. Let's get as far as we can. Let's do our best. Okay. Page 60, y'all. Ooh. Okay. All right. Whereupon a recess was taken. Okay, court. This is Judge Dunaway. All right. Well, all right. Very well. Let's go back on the record with Mr. Williams' case 24SC001723. We've taken evidence. I understand the defense has no evidence and the state has no other evidence. So I will hear the argument. I guess ADA Wooten, you have the burden, so you can go first and last. Judge, actually, as it relates to the standing issue, they have the burden. I can go first, but I can provide the case law on that. They have the burden as it relates to standing. We do have the burden in regards to standing. However, we literally argued that ad nauseum. The issue here, the state still has the burden to prove before we present anything in regards to the bigamy and fraud. So the standing, yes, we do, but I believe the state has the burden for this particular issue we're arguing right now. But I mean, whatever the court wants to do, we can do. Thank you, Jen F, for supporting. I appreciate you, sis. Thank you. Um, who wants to go first? That's what. Who wants to go last? Judge, I can go. I can go. I'll hear from everybody at least twice. So go ahead, Mr. Wooten. Thank you, Judge. And as Mr. Hoover stated, we've done a lot of arguing in the pleading. So I'm going to try to keep it succinct as I can and then take any questions the court may have. But I do want to start at the burden of proof issue as it relates to standing. And I think that's where we start and ultimately where we end because and I'm starting with Rikers versus Illinois 439 and it's 1987 United States Supreme Court case. It was adopted in the state of Georgia and Statinsky versus State and that's 2007. I'm going to skip over some of the citations for the statutes. And the reason I start there is because, again, the factual question before the court today is standing. It's not the substance of the search. We've already had a hearing on that last December. And so Rikers in Statinsky, both the United States Supreme Court and Georgia Supreme Court have held that where a defendant cannot establish both subjective expectation of privacy, that is that he himself believed he had a reasonable expectation of privacy in a location and a legitimate object of expectation of privacy that he lacks standing to challenge a search. And in both of those cases, the court have emphasized that as it relates to the threshold standing question, it is the defendant who bears the burden of establishing both the subjective expectation of privacy and the objective reasonable person expectation of privacy, which has further been defined and flushed out by the courts to mean an expectation of privacy that society is prepared to accept as legitimate. And so that's really the question. Has the defendant proved by a preponderance of the evidence that he had a subjective expectation of privacy, number one, and number two, has he provided that whatever the subjective expectation is the one that the court and society is prepared to accept as legitimate? Oh, shit. And so because it is the defendant's burden, he got put up, he's got to put up evidence as it relates to both of these things. It's rare that the state gets to say this, but the defendant hasn't proven anything as it relates to either of those factors. He's put up no evidence. Only the state has put up evidence and witnesses. We've heard nothing at all about the defendant's own subjective expectation of privacy, and the state's certainly doesn't stipulate to that. And the state, even though the defense has put up no evidence, the state has put up evidence that even if there is a subjective expectation to privacy, that it's not one that the court should accept as legitimate, and it's not one that society is not one that society is prepared to accept as legitimate. And as it relates to that question of whether or not an expectation is legitimate, there's a long line of federal cases and there's a long line of Georgia cases that talk about what that means. And so, of course, the court knows that means something like, if DDA Winfrey and I were charged together in an indictment and her house is searched as well, I didn't have standing to challenge the search of her house, of course. but the courts have over time given us some information on how this works when the area that is the subject of the search is procured by fraud. And so we've got a whole long line of cases that say a defendant cannot have a reasonable expectation of privacy in a location that is procured by him by fraud. And so I want to just start with the cases. Okay, according to the judge. So if you don't know, I guess I'm going to just explain it really quick. At the end of the day, Nesto is claiming that he had an illegal search and seizure of his Ford F-350 where a bunch of receipts were found that support the RICO case. Even though with the RICO, the district attorney said that they have plenty to argue the case without the receipts and things that were found in the F-350, it's germane to another case. So they don't want to have the evidence thrown out because the evidence is useful in the case, even though they don't need it, but it's essential to other cases. So that's why they're really trying to push this. But at the end of the day, Nesto purchased this vehicle with his wife's name. Now, under normal sets of circumstances, he might have a leg to stand on because married couples can use each other's information, even though in this case, Shirley is adamant she did not give permission. But considering that they were involved in a void, phony, fake marriage, and she was deceived, she was not aware that he was not really her husband, even though they were operating as a married couple. Therefore, the marriage is fraud. Any transactions that they were doing within the confines of the marriage are not given marital privilege because there wasn't a real marriage, right? Okay, that's it. So anything else we'd have to, let's just keep separate because we don't have all night. But that's basically the gist of this. He can't claim the privileges of a husband and husbandly type transactions with a wife because the marriage was void. She was being conned. She was scammed. And she thought it was a marriage and it was not. So he can't really claim the car as a marital asset because guess what? The marriage was void. Okay, so hopefully if anyone was confused about that, that makes sense. And if it doesn't, we'll talk about it another time because we need to get through this document because it's long. It's very long. Okay, that's basically what they're arguing right now. So if anybody's kind of confused what they're talking about, that's what they're talking about. Okay. And given the court kind of a survey of how that was deployed over time, and by far, I would say the broadest area where we see this come up is when the car is directly stolen. So they're going to go into some legal arguments. This might be a little confusing or just a little bit more than what we want to talk about, but they're basically giving a couple of scenarios when like somebody who steals a car and you've got a bunch of pot in the damn trunk. If the police engage in an illegal search and seizure, it's not illegal because it's not your damn car. If you are driving around in your own vehicle and you have a bunch of pot in it, and I guess they don't have probable cause, and maybe you're saying you're profiled or whatever, you do have the right to a certain amount of privacy because that is your vehicle, your property, and all of those things. But in a stolen vehicle, you don't get the same rights because it's not your property. It's stolen property. Okay. The defendant, so this is what they're arguing right now. A defendant murders someone and steals their vehicle and flees the stolen vehicle. The vehicle is searched. They challenge the search, and routinely that means, I think without question, the defendant doesn't have a right to challenge that. I'll give you a couple of cases that speak to that. First, Burgesson versus the state. It's 1996 stolen vehicle, and the court held that the defendant had no standing to assert the violation of the Fourth Amendment right because she had no property interest in a stolen vehicle or legitimate expectation of privacy regarding the vehicle or its contents. Let me tell you another sticking point. So basically, the technicality of the vehicle ownership and the marriage is something that came into play well into the process of this case. So Hoover is standing on, at the time the vehicle search was done, the law enforcement was not aware. That's why they were asking, did you know that there was a bigamous marriage when he was arrested? No, they did not. So that particular technicality was unknown at the time that he was arrested. So by hook or by crook, the state became aware of these technicalities into the case, because Nesto really could have possibly gotten this evidence dismissed, because the search probably was not 100% legit at the time. They were kind of going on a hunch, maybe not necessarily valid probable cause. But as fate would have it, because God don't like ugly, Nesto has done enough dirt that his dirt came back to bite him in his ass. Number one, identity thefting his wife, and two, being a bigamist against multiple women. So because of that technicality, he can't claim the vehicle as a regular owner of a vehicle would, and an illegal search and seizure and a violation of his Fourth Amendment, because guess what? The vehicle is not really yours, what we just talked about. Okay. So that's that. Okay. And the court goes on to expand the they and say, on the contrary, as one knowingly uses a stolen vehicle on a public roadway, the defendant probably was in constant expectation of intrusion by the authorities. And so I'm going to keep moving through the cases, but I'm going to come back to how that applies here. Another case, Brisbane versus State, 1974. The court said, I'm going to skip a little bit. And the court said that the person is in unlawful possession of a stolen vehicle should be in no better position to assert a claim of invasion of privacy with respect to a search of a vehicle than would appear a trespasser on real property. I've cited some other cases dealing with stolen vehicles in the pleading, and so I won't just list a long line of cases, but they are in the state's motion to dismiss, this motion to suppress. But moving on from stolen vehicles, the same rationale can be applied by the Georgia courts in other contexts. And so I've got a few I think that are relevant. First is the State versus Del Vecchio Court of Appeals case, 2009, Georgia Courts of Appeals. In that case, a search at issue is at a hotel room. And so the court knows searches of real property are given little but more protection than searches of vehicles in the first place. But in that case, in the case of the vehicle, the hotel room was obtained by fraud, because like in the case of a stolen identity and stolen credit, there were used to rent the hotel room that was searched. And the Georgia Court of Appeals acknowledged and registered legitimate registered guests of hotel rooms can have a reasonable. So if you committed an act in a hotel room, you have a right for them to get a search warrant to search your room. But let's just say you used a stolen credit card to secure your room, they can go ahead and bum rush the room. Number one, they're coming on some stolen credit card. And second, because the hotel room was obtained fraudulently, you don't have the rights of a lease for the night. Technically, you've leased a room for a period of time if obtained legally. If not obtained legally, it's a fraudulent transaction. And due to the fraudulent transaction, you have no rights to privacy in that room. Okay. So they're just using this as an example to plead his case that Nesto doesn't have any of the privileges of ownership of the vehicle, because number one, Shirley's not your wife. You frauded her. It was bigamous. And furthermore, you identity thefted her to purchase the vehicle, because as a husband may be able to use their spouse's personal information to make a vehicle transaction, considering that you were not legally married and this was a fraud marriage, you didn't have those rights. And so, like here, the Ford F-50 was procured solely by fraud. And I'll talk about that more in a minute. Mr. Williams cannot have a reasonable expectation of privacy in that vehicle that he was driving only because of fraud committed by him. I want to hit a couple of federal cases, which I think are instructed because this is of course a Fourth Amendment question. The first is United States versus Cayman, 2005 Ninth Circuit case. A laptop was purchased using stolen credit card. The laptop was searched with a warrant. Officers found child pornography on the laptop, and then there was a challenge to the search of the laptop. The Ninth Circuit held that because the district court below found Cayman obtained the laptop computer by fraud, he had no legitimate expectation of privacy in the contents of the hard drive. Let me say this too, since he brought up this case, which I don't think this case has anything to do with Nesto's situation with his GTAC computer. But since Nesto wants to always say that Shirley purchased that GTAC computer for him, he has no expectation of privacy in the GTAC computer that had the child pornography in that either, because guess what? Shirley wasn't your real wife, and you want to just always keep saying that Shirley purchased it for you. So guess what? You don't own the computer either. How about that? Hello? We see no ground on which to distinguish property obtained by fraud from the property that was stolen by robbery or trespass. And so, as you see, Your Honor, I kind of building how this goes from stolen vehicles, trespassing, and fraud. The courts are treating them all the same. I also want to touch on another federal case, United States versus Johnson, 2009, 10th Circuit, and it goes to the search of a storage unit that was rented using identity fraud. So using someone else's information to rent out a storage unit, and I'm going to read a block quote from the case. The court said ultimately that the matters is not whether Johnson might have some legitimate property interest in the storage unit, but whether Johnson's interest is one that the Fourth Amendment is intended to protect. Arguments such as those Johnson advances here do not distract us from the fact that a fraud was perpetrated and the victim was a third party. We will not be a party to this fraud by legitimizing Johnson's interest in the storage unit. Therefore, whatever subjective privacy expectation Johnson had in the storage unit were not expectations that society is prepared to recognize as objectively reasonable. Johnson thus did not have any Fourth Amendment rights to the unit and could not expect that the police were required to obtain a search warrant or establish an expectation of the requirement in order to search the unit. And so, kind of moving to the facts of this case, Judge, I want to share on the screen just a little illustration of a timeline, because the state's position is that there are two areas of fraud. There's a general big picture of fraud as it relates to the bigamous relationship, which is the only reason that this defendant had any access to Shirley Strawberry's life. And then there's a specific fraud of his using her identity to purchase this vehicle. And so I'm going to start with the bigamy. And so I've created a little timeline. There was some testimony that came out through a cross-examination that there has been no evidence presented or whatever that the marriage between Mr. Williams and Ms. Strawberry was bigamous at certain points in time. So I created a timeline to kind of illustrate what actually the case is. So starting with wife number one, Edith Miller, we know and have proven that there was a marriage October 22nd, 1985. I asked the investigator on direct if he tried to find out if there was a divorce. He testified that he did look for a divorce. He could find no indication of divorce. The same fact was repeated on cross-examination. And I would remind the court again, going back to where I started, that it's the defendant's burden of proof as it relates to the standing issue. So every single fact the defendant wants to use in support of his position has to be proven by him. And so the fact that he can't show that there's no divorce on number one, it's up to them to show that there was a divorce that predated any of this stuff. And number two, the only testimony before the court is that there was a search for a divorce and it revealed no information. So that's wife number one. Wife number two, Martha, and you've seen definitive proof that the defendant married on September 1st, 2001, and divorces her 20 years later in 2021. You've also seen definitive proof of the timeline of marriage between the defendant and Shirley Strawberry. He married her in 2015 and the divorce was final in 2024. And so the evidence certainly shows at least a preponderance that I would submit by far more than a preponderance at the time that the defendant married Shirley Strawberry, at a minimum, he was still married to Martha Halliburton, and an absolute minimum that he was still married to her. And we would also submit that he was also married to Edith Miller at the same time. I'd also point out that if the court recalls Exhibit 3 as it relates to the existence of the Miller marriage, Exhibit 3 is the marriage license application between Mr. Williams and Ms. Halliburton, and the defendant stated that he had 0 previous marriages. We all know that is a lie, okay? We all know that is a lie. And so I think that further supports the circumstantial evidence that the defendant was never divorced from Ms. Miller. So as I stated, bringing it back to the defendant married Shirley Strawberry, we know for sure he was married to Martha Halliburton. That is unrebutted evidence, and that he was married to Edith Miller. Likewise, the date of the stolen vehicle, the date of the purchase of the F-350, it's a little bit covered up on the screen, but January 28th, 2020. At which time, according to the evidence between the court, the defendant was still married to all 3 women. My God. If you have not hit the like button yet, hello? Okay, you guys are doing really good on likes. I'm not even gonna say, you guys are almost at 500 likes, okay? Y'all, excellent. Thank you so much, y'all. Thank you for supporting, okay? Ooh, okay. At which time, according to the evidence before the court, the defendant was married to all 3 women. At some point, he did divorce Miss Halliburton. That was by her own doing. But that came after the purchase of the vehicle. So the fact that, the Halliburton marriage had been dissolved prior to the defendant being arrested in the vehicle is of no consequence. The question is, was there fraud being committed at the time of the vehicle was procured? The answer is yes. And I also add in that, as Miss Strawberry testified, she did not know about this fraud until the defendant was arrested and the bill collectors came knocking at her door. So even if that Halliburton marriage was dissolved, I don't see how that makes any material impact on the standing question, because as Miss Strawberry testified, she wouldn't have let the defendant access her life had she known that he was married to 2 other women. She wouldn't have married him had she known that he was married to these other women. And at the time the vehicle was purchased, he certainly was married to at least 2 other and potentially 3 different women. So that's what I would assert as ground 1 as it relates to the procurement of the F-350 by fraud. Just generally that the entire marriage was fraudulent, and therefore the defendant should not have the benefit based on his relationship with Miss Strawberry by deceiving her into marrying him. Then moving more specifically into what I would call the specific fraud being the purchase of the vehicle itself. And the court heard, as we just meticulously went through this document through Exhibit 1, both from Miss Strawberry and Investigator Ansel, going back to where I started, it's the defendant's burden to prove that he was standing. He put up no evidence. This is the evidence before the court, and we submit that it shows the vehicle certainly was procured by fraud. Miss Strawberry testified that she has not seen this document until today. Thank you for dropping some gifts, y'all. I appreciate it. Let's be clear, okay? I think we're being very clear on today. Thank you so much, hon. Thank you. That she did not know that the vehicle was purchased in her name until after the defendant was arrested. The bill collectors came knocking at her door. We've walked through the information that was put on the application, and it shows pretty clearly that it's the defendant who is the one that did this, starting at the phone numbers listed for Shirley Strawberry. Came back to Alasia Alexander, who is known as an assistant, is one word that would be used of the defendants. She comes up a little bit more in the sex cases. Ooh, what? Well, we know this already. Okay. We know this. Miss Strawberry came back to the telephone number listed for Miss Strawberry came back to Alasia Alexander, who is a known assistant, is one word that could be used of the defendants. She came up a little more in the sex cases. But moving down the line, Miss Strawberry testified that she would not describe her title as I Heart host Steve Harvey, that she would have described her title as co-host of the Steve Harvey Morning Show. She testified that she doesn't know anyone named Carlos Lamont. Okay, hold on. I'm going to have to take this off the screen. It's going to show a phone number. She testified that she doesn't know anyone by the name of Carlos Lamont, that she's certainly not a relative of hers. You heard testimony from Investigator Ansel that the phone number that ends in 0141 came up to Earl Lamont Dunbar, who is again a known associate of the defendants. They regularly talk. They have regularly spoken on jail phones. Investigator Ansel testified that he has listed those phone calls and described their relationship as close. So I think it's fair to say that's an accomplice of the defendant who would vouch for him and assist him in this fraud. Oh my God. And then you also heard Miss Strawberry name Fonta Ellis and that phone number that investigator Ansel spoke of to the owner of that phone, who told him that her daughter had used her phone number in the past and she believes her daughter is an associate of the defendant. Notice how they didn't mention who the daughter is. Okay. We don't know. We know Fonta Ellis has a daughter who is a known associate of Mr. Williams, but they didn't mention who the daughter was. Okay. So there is a theme here. All of these people, all of these phone numbers that could be used to verify anything as it relates to the purchase of this truck, all came back to the man sitting at the defense table. They all came back to him. Miss Strawberry doesn't know who any of them are, and she didn't authorize any of it. Just moving briefly through the document, there's 1, 2 times that her signature is used without her authorization, 3 times, 4 times, 5 times, at least 5 times that her signature is used. Her name is used throughout her without her authorization. She didn't know about it until the defendant was arrested in the vehicle and has testified, Judge, yes, she's still paying the vehicle. She said she's paying about $900 a month on this vehicle as of today, every single month. But she's doing that because she knew anything, but she did not know because but she's doing that not because she knew anything about the vehicle, not because she authorized the defendant to purchase it, but not because any reason other than she wanted to protect her own credit from being impacted based on the defendant's crimes. She also testified that she reached out to the financing company, tried to clear this up, but they would not do anything about it. She was asked why she did not reach out to law enforcement, and she said she didn't as well. And she said law enforcement, and she said that she didn't. Well, one, that she may have spoken to the police officer about it, and she didn't know that she could come to the district attorney office to see if there was anything that we could do about it. But it's very clear, and again, keeping this in context of it, the defendant's burden of proof, defendant put up no proof. The state put up proof, and proof shows that Miss Strawberry did not know the vehicle was purchased and that the defendant is the one who did it using her information. And so based on all of that, Judge, we would submit that this defendant has no standing to challenge the search of this vehicle. He procured it by fraud through at least 2 different ways. His procurement of the vehicle by fraud cannot be the basis for an expectation of privacy that society is prepared to recognize as legitimate. This court should not recognize it as legitimate, and the inquiry should end there. The motion to suppress should be denied, and if the court disagrees with that, we've laid out all of our pleadings and arguments previously before the court. We also don't believe that there is that any of the expectation of a few things that were identified in the pleading, that the evidence of the defendant challenges the fruit of the poisonous tree. And with that, I would take any questions the court has, but nothing further on behalf of the state. All right, so the state's exhibit 1, I heard the testimony and I understand what it is, what the evidence that Mr. Williams filled out this form, told someone to fill out this form and put. I understand that Miss Strawberry said, I didn't do it. How do we know that Mr. Williams did it. Yes, Judge. And again, first, I'll point the court back to its defendant's burden of proof to disprove this. It's not the state's burden of proof. However, circumstantially, the number one thing is that he's the one driving the vehicle. And so if someone else put all of this together, wouldn't they be driving the vehicle around? He's the one that's driving the vehicle around for 2.5 years between that day and all of this happening and the day that he was arrested by Roswell Police Department. So that's fact number one. Circumstantially, that shows he did it and was an accomplice in it. Number two, the fact that, as I pointed out, all of the contact information for references, family, and friends, even the contact information that's listed for Miss Strawberry herself, are individuals that testimony before this court is that those people are all accomplices of the defendant. Alasia Alexander, who goes by Dominique, is an assistant to the defendant. She's involved in some of the other crimes in the indictment. Her phone number that is listed as if it were Shirley Strawberry's. Hold on. Number two, Carlos Lamont, who is listed on there with the phone number that comes back to Earl Lamont Dunbar. As you heard, as the court heard, the evidence before the court is that, again, a known associate of the defendant. They talk on the phone while he's in jail. They talk about finances. They talk about running around, doing business together, and it was described as a close friendship. And then third, the kind of backup that Mr. Williams, we submit, he put on here is the Miss Falta Ellis reference ending in 5653, which again, the testimony was investigator Ansel reached out to that phone number. She stated that the person who owned the phone number said that her daughter used it and believes that her daughter is an accomplice of the defendant. And so I remind the court, actually, I take another step back, Judge. If you just look at the very top line of the credit application where it lists Miss Strawberry's name and lists the birthday, her birthday, which is Mr. Williams, would have access to, because he's fraudulently and reportedly her husband. He has access to her birthday and also a list of full social security number. We've redacted it so that we redacted it, but he had access to it. There was also no evidence that anyone else would have access to it, but common sense tells you they're living together. She thinks they're married, and so he has access to her personal information, and so has access to her personal information and also uses it on here. And then again, right up to now, Judge, I think the number one thing that he's driving the car around, and he's at least at the beginning making payments on this vehicle. Okay. So I don't know why anyone else would let him drive the car around, that they would be making payments if it wasn't for them. So I understand in my head, the state's exhibit 1 is the credit application, the truck and the car itself. Usually they are registered in someone's name with a county tax collector. Do we have the registration of the truck? I believe I do have it, Judge. And I asked the witness when the car was put in her name, and she didn't know. I can certainly, it's public record, so I can certainly pull it. And if the court would want me to pull it and I can submit it, I can do it within the next 48 hours as a supplemental exhibit. No, I didn't know if we had it somewhere, but you believe that there is fraud in the financing application. There was sufficient reason to not have an expectation of privacy. Judge, it's not just the financing application. There's actually 2 documents in the exhibit. Okay. There's the financing application, and then flip to about the 6th page. There's the actual retail installment contract and security agreement, and it's an actual contract for the purpose of the vehicle where the defendant binds herself by contract. I see the buyer's name, Shirley C. Strawberry, understood, and at 28% rate, didn't even bother to get her a good interest rate. Damn. Your Honor, I'll object to that. Sustained. I mean, come on. Sustained. Okay, all right. I do see there's a second document. Okay, very well. Anything else, Mr. Wooten? No, Judge. Attorney Hoover? Yes, Your Honor. And I tried to streamline this just as much as I could so we're not here forever. First, Your Honor, may I approach with some case law? Yes, sir. So I'm giving the state the case law that I'm about to quote, and I'm giving the court as well. Thank you, sir. So, Your Honor, I would like I said, I tried to streamline this as much as possible. First question that I have for the court is I'm going to address, but the question that keeps popping up in my mind while I've heard testimony going over what the state's argument is, one, who exactly is the victim in this issue? So the state literally been, well, let me back up. For starters, we all started because Officer Fields at the time committed a warrantless search of the vehicle, and the court is already aware that the Mr. Williams is driving it legally. There were no issues with the vehicle. It was parked. It wasn't even near the vehicle. She got in because of a faulty alerted dog, they claim, but it all started because she violated Mr. Williams' constitutional rights by searching the vehicle without a warrant or probable cause to. During that hearing, the state never brings up any of this fraud, never brings up any of the bigamy as to Mr. Williams doesn't have standing. It's only, and I believe I've lost count at this point, it's only 4, 5, 6 months later that the state almost completely abandons their first argument and goes straight to, well, there's bigamy and fraud. But in their briefs, their arguments and testimony that presented today, I'm still having an issue with figuring out who the victim is. So Mr. Williams defrauded and purchased a vehicle from a company through fraud, and then would make the company he got the vehicle from as a victim, meaning if I purchase the vehicle, I make payments on it or do something, they repossess it and they're the victim, they're the ones that take the car back. The state doesn't make that clear. So then that means Miss Shirley Strawberry, the victim in this case, because it was in her name. So if Miss Strawberry is the victim because the vehicle was in her name, which I'm going to get to, well, that kind of defeats the whole issue because the company isn't the problem and doesn't have the problem. Miss Strawberry does. So there's a moving goalpost, and the state literally has been jumping between the entire time. Let me tell you something. This argument that he made solidified that Wooten went back to his office and went and sought those additional charges because, damn it, if you're going to try to throw out my argument as baseless, I'm going to go ahead and get an identity theft situation started so Miss Strawberry can go to Westlake and tell them that this vehicle was procured through fraud, and she can sue them and try and get her money back. So at the end of the day, Wooten trying to fight this really is going to end up doing Shirley a favor in the long run because she might be able to sue and get her money back, not because Westlake did anything, but they were not prudent in the executing of this contract, because little did they know they executed a fraudulent contract with bogus signatures and bogus information, and she could sue, at least even just to get it out of her name and for them to settle. Like they could just settle it out, maybe not hand her a check, but they could just take the vehicle, get it out of her name, and maybe give her some money back. I don't know, but it could end up in her favor by them filing charges on Nesto, because now it's been legitimized that there was a problem with the executing of this contract. So This was stupid. This was dumb. I get what Hoover was trying to do. At the end of the day, Fields did execute a bogus search, but the bottom line is, like I said, the God don't like ugly clause. The bottom line is, yeah, Roswell PD did mess up and did violate, if according to them, that's how they searched the vehicle. But the bottom line is, because he was engaged in fraudulent lifestyle on top of all of that, he doesn't have the privileges to stand on his argument of Fourth Amendment. And yes, it is kind of the debate of what came first, the chicken or the egg, but that's been a debate since the beginning of time. It's a chicken or the egg, which came first argument. And at the end of the day, yes, they violated him, but technically they didn't, because the vehicle was obtained by fraud. And that's it. And that's why what happened. If you don't know, we'll talk about it at the end. We're almost done, so maybe I can make it through this before my husband gets home. Girl, let's see. Okay. Where was I? So there's a moving goalpost that the state literally has been jumping between this entire time. Again, this is a completely new argument from that we've been arguing for years. I mean, well, not years, but we've had this case for years. But this new argument is that we've brought up. And I ask that, Your Honor, because there are some dates that don't quite add up. Now, during the testimony of Miss Strawberry, we'll know the vehicle was purchased January 2020. Miss Strawberry said she found out the vehicle was not that she started making payments herself. Miss Strawberry stated she found out about the vehicle, not that she started making payments herself. She first found out about the vehicle in 2019 or 2020. So we know the vehicle was purchased at the beginning of 2020. That's when she found out about the vehicle. She doesn't allege fraud or allege something that was put in her name illegally until when she said Mr. Williams was arrested. So that in July 7th of 2022, so between January of 2020, for over 2 years, she knows that the vehicle exists. She knows that her husband at the time was driving the vehicle. She's been in the vehicle herself and has taken no steps whatsoever to say this is fraud. Who would do that? That's your husband. Obviously, she didn't mind at the time for your work. Secondly, personally thought that Ness still had a connection to that dealership, and I think so too. I think he used Westlake. Yeah, they were his seller of choice. Thank you so much, Miss Bougie Down. Thank you, hon. She knows that her husband at the time was driving the vehicle. She's been in the vehicle herself and has taken no steps whatsoever to say this is fraud. And I find it interesting that even as of today, Miss Strawberry still claims that she had no idea that the vehicle was in her name. It just doesn't make sense. Now, here is the issue, Your Honor. Before I get into the case law, Miss Strawberry, that the evidence is clear. Miss Strawberry didn't change the bank account information once Mr. Williams was arrested in 2022, and that means is from January of 2020 up until, I guess, now, her bank account, her personal information account, has been making payments to the vehicle. Not only has her personal account, she could be calling and just putting in her debit card number. We don't know how. You didn't ask how she was paying for it. You asked a stupid ass question of, did you change your account information? That doesn't mean anything to anybody. Not only has her personal bank account been making payments on the vehicle, but her personal bank account has been paying the insurance on the vehicle, and none of that ever changed. You asked her, did she change her account information? You didn't ask her, did she change her payment information? This guy is stupid. Account information doesn't necessarily mean payment information, if you're listening, Roberto. Okay. So at the point where Miss Strawberry knows the vehicle exists, she knows the money is coming from her personal account for the vehicle, and the insurance doesn't turn into an, oh, this is fraud until later. And I have a case that addresses, when it comes to the stolen car argument, the state was bringing up that there's really that, but that's really important, because even after she finds out about the vehicle and even after Mr. Williams is arrested, she says, oh, she started taking over herself. It doesn't make sense that her personal information never changed. I think he's conflating two separate things, payment information and account information. Also, he's looking at today, a divorce, and not looking at July 2022 when she's waiting for her husband to get out of jail. And this is a car that he intended to drive had he gotten out and they had been able to save and revive their marriage. Okay. Now, number two, Miss Strawberry is there, and there is case law that I'm going to support on this as well. Miss Strawberry never took steps to get the vehicle out of her name. Now, that's important because in the state of Georgia, there's actually laws that say if a vehicle is procured in your name, you can give it back to a company and it doesn't go against your record. If she believed, we still don't know when she honestly or allegedly believes that the vehicle was procured through fraud. But what we do know is that she never, even at the divorce, she never took the steps to say, I don't want this vehicle. It was procured through fraud. Let me do a police report. Let me take it back. Maybe she didn't want to add to his misery. Maybe she didn't want any more trouble. She's got a visible, high profile job. Maybe enough is enough, and she wasn't trying to add to his misery. That's what I would think, but whatever. She does say that she reached out to Westlake, which is brand new to pretty much anyone that has anything to do with the case, and there is no evidence whatsoever of what happened in that. And I want to make that clear because, again, we're trying to figure out who the actual victim is, and if the person was the actual victim, that the information was known and when. And now that's really important. That's why I think Wooten went ahead and filed those charges, and created the identity theft case, to make it clear who that there is a victim, and that to make it abundantly clear rather than speculate that there was a crime committed. And that's why now you've got another charge, another case, and then another case. When it comes to the different marriages in Georgia, when it comes to the bigamy, Your Honor, the state is right that once they prove that, let's say, an ex-wife or an ex-husband is alive, and the next step is, okay, well, did that other person know about it? The issue that the state keeps glossing over is, was there a reasonable belief under bigamy? Mr. Williams had to have known, had to have purposely known he was still married to someone. He had to purposefully, I hate how they use the word contract, but contract with another person to be married. There's no evidence whatsoever that Mr. Williams ever actually knew that he is, or is, that none of his previous marriages were dissolved. And they say that, Your Honor, because in the States too, when talking about the marriage to Miss Edith back in South Carolina, there's been no evidence whatsoever that the marriage still exists or still exit. There's been no evidence whatsoever that the marriage following that marriages were void or were dissolved because he's still married at that time. And Your Honor, we've gone over Mr. Williams' record the entire time. There's nothing to show that there's nothing to show that the marriage was not dissolved at the time that he moved forward. It goes into show that states 3, the marriage to Miss Halliburton, again in DeKalb County, no court of law, no office, there's no jurisdiction that said, you know that this is wrong and can't do this because you're married to someone else. Well, it asks, do you have a legal impediment? And marriage would be an impediment to not get married again. Again, when it comes to Miss Shirley Strawberry's marriage to Mr. Williams, again, there's nothing to say that Mr. Williams knew he was marrying someone else, knowing he was already married. Now the state wants to tell you that we didn't put up evidence to show that he didn't mentally have the concept of it. Like, that's not how it works. They put up their evidence to show that there were 3 legally valid marriages. None of those marriages ended because it was void because of something else. And the biggest part is, Your Honor, Miss Strawberry filed for divorce against Mr. Williams. That's extremely important because if what the state is saying is true, if he wasn't still married to at least one of the other women that she was married to, then divorce wouldn't be a legally binding contract in Georgia. She would have gotten it annulled. That's more important, Your Honor, and that the state didn't want me to talk about this, but her attorney, her divorce attorney, used to be an attorney for the district attorney's office. So she understood the difference between the annulment and the divorce. It's possible Shirley called that lady for a divorce. In the process of getting the divorce, maybe she became aware that there was some sort of bigamy issue. The bigamy issue hadn't been proven yet, and Shirley wanted to be divorced. And maybe she thought it was the best means. Who knows? They need to depose the lawyer and ask her, call Edith and call Martha. That's what you need to do. Start dialing and do some depositions and get those answers, because they're going to need to do all of that before the trial ever starts. Okay. Because this is ridiculous. There's a whole lot of fraud going on. Yes, Butterfly. To quote Kevin Majeski, there's a whole lot of fraud going on. Okay. Now, an attorney that knows the difference between an annulment and a divorce has a client and puts her through a divorce and not an annulment. That's either she's ineffective or it's not true. And the state never put up any evidence that it's not true. Even now, the divorce was finalized. It's been settled. The state didn't come back and say, well, she's taking the steps to get it annulled now that we know this fraud happened, or she's taken the steps to get it annulled now that we know there was bigamy. The reason why, Your Honor, is because they don't have the evidence of it. That we have is maybe her attorney that used to be a DA told her he's married to multiple people, doesn't give any other evidence other than, but she puts her through a legal contract of a divorce instead of an annulment. That's extremely important. Now, when it comes to the case law itself, Your Honor, and you have all of this case, United States versus Revo and Rivera, the 10th Circuit, 1990, and it has the holding that where a defendant offers sufficient evidence indicating that he has permission of the owner to use the vehicle, and the defendant plainly has a reasonable expectation of privacy in the vehicle and standing challenge to search. Now, I say that, Your Honor, because at the moment that Mr. Williams was arrested, we know Ms. Strawberry knew about the vehicle. We know that the payments for the vehicle insurance were coming out of her personal account, and we know that a probable cause or a reason underlying basis to get into the vehicle had nothing to do with the fraud or nothing to do with the bigamy. Based off of the case law, and had permission from the owner to drive it. Officer Fields even says that I've seen Mr. Williams drive in the vehicle all the time. Moving to the next point, now the state quoted a lot of cases that they talked about. The stolen vehicle itself was hypothetical. They specifically bringing up Radkis and Stinsky. I always say that case is wrong, but Your Honor, there is a difference between Radkis and Stinsky and the cases the state quoted in regards to stolen vehicles and what's going on in front of you today. That case literally is dispositive factor of Radkis and Stinsky and Hargrove was that the vehicles were actually stolen. The defendant attempted to conceal the vehicle's true identity, and the defendant did not challenge the status of the vehicle. In this case, Garcia did challenge the status of the vehicle, and the court said it's different from the case that the state is quoting because this defendant actually quote or challenged the status. Now I say that because the case the state quoted had to be with, I believe, one. There were co-defendants that killed a woman, stole her car, and drove off. They knew one of the co-defendants was the last person around her. They saw the car, which matches the Bolo. They knew the car was stolen. They never challenged the validity or whether or not that car was stolen. Another one, there was a armed robbery. I'm sorry, not an armed robbery. Someone stole a person's ID, rented a vehicle, went into a high speed. They fled with a little bit, got arrested. They didn't contest the fact that they didn't have the car legally. In Garcia, Your Honor, Garcia contested the fact that he didn't know the car was stolen at the time. He thought he had permission from the owner. The court said they were absolutely right. You do have standing. In that court, the state brought up what society recognizes. The court actually says in the rationale of the individual has the owner's permission to use the property. Society surely recognizes this as reasonable. It goes into, quote, United States versus Miller. Defendant's use of a vehicle with the owner's permission provides the defendant with subjective expectation of privacy that is reasonable and legitimate. And I believe that is extremely important because it cuts directly against the case of state quoted in regards of, so basically he's saying, well, I feel like he's almost saying, even if you factor in fraud, he wasn't aware that he wasn't married, so that his marriage wasn't legitimate. He wasn't aware that he was a bigamist. So if you're giving him like favorable light, he wasn't aware that he was committing a crime. So he thought that the car was his. He would have had permission through his marriage and through his relationship with his wife. So it wasn't an intentional fraud. It's almost like, to me, they're saying that this was kind of like an unintentional fraud, which that doesn't mean anything. It's still a fraud to me. They represented no evidence whatsoever, and I'm going to get on that in a little bit, but Mr. Garcia did the exact same thing, and the court, plus the 11th Circuit Court since 1987, has said that the person that's standing if they are challenging the status of the vehicle. Now, rental car exception. All right, now the rental car exception. Okay, we're almost done. I'm like, oh my God. Let me get some sips of water. Oh my God. You know what I'm going to say? I'm going to say that he's not going to win the appeal. He's just not. Dunaway already is not allowing. I don't think that this is going to pass muster. They can appeal it all they want, but okay. Now the rental car exception, Your Honor, it was very similar. I have a case for you, United States versus Henderson. The confidential informant said they knew someone that was part of a armed robbery with me. He identified the vehicle and that person. The FBI finds the vehicle, impounds the vehicle, and they find in the vehicle evidence of the armed robbery. Now the state tried to say because of the rental car. Hold on a second. Okay, rental car. So that means that he had to turn that back into the rental company. He shouldn't have standing to challenge it anymore. But the court said in Henderson was that Henderson still had standing to challenge the search of the vehicle. The rationale, quoting United States versus Cooper, they say that the 11th Circuit was held that an arrestee may have a reasonable expectation of privacy in a rental car even after the rental agreement is expired. Although the lease had expired, the rental car company had not attempted to repossess the car. Now that's similar to the issue that's before the court today, Your Honor, Ms. Strawberry. Well, let me back up. The company, Laura's Trucks, they did nothing. They took no steps to repossess the vehicle. That's the issue with the case today. And again, Miss Strawberry knew the car existed. She knew Mr. Williams was driving it, knew it was coming out of her personal account. She never took steps to repossess the car or take it back. She never said it was coming out of her personal account until she was required to pay for it. He asked her, did she ever change her account information? She said no. Account information is different from payment information. So he's taking that to mean that she was paying for it and was still paying for it. She never said that. She never takes steps to repossess the car or take it back or do anything other than allow him to drive it. Well, they're married, dummy. Now this is all, to me, his vague understanding of the relationship between Shirley and the car, I think, really illustrates how little Nesto is telling Hoover about his relationship with his wife, because Hoover sounds like an idiot because his client is an idiot and his client isn't giving him enough information to be able to articulate the relationship and what they actually had going on. So he sounds like he has no knowledge about these people and their relationship. And it's like, we, the people, know more because he's over here fighting LWAP. So he hasn't had time to get to know Nesto, and Nesto's not giving him anything. And Sonia is a complete fool. If Hoover wants to know why you lost this argument, call somebody that goes to this chat. Call anybody, email anybody, comment under anybody that frequents this chat, and somebody will explain it to you, Mr. Hoover, because your client is not helping you at all. He doesn't seem to understand the dynamics of this relationship, and he sounds very lost, and he's not going to win this argument. He didn't win this argument, and he's not going to win the appeal, because to me, he doesn't have the basis of this relationship. The relationship ended up dissolving, but it wasn't dissolved at the time that the fraud was found out until Shirley decided to end the relationship, and she was in the middle of the divorce. It's possible the divorce attorney didn't find out that he was bigamous until in the divorce, because when the divorce started happening, his lawyer, to me, I think she had just gotten wind of the bigamy and they had already filed for divorce. She had just gotten wind of it, and they did mention it, I think, in the divorce filing, but I don't think that she knew a whole lot about it. Anyway, she never took steps to repossess the car or take it back or do anything other than allow him to drive it. Now, the state did talk about the fact, well, if Miss Strawberry knew this, then when wouldn't have let him drive it in the first place? She wouldn't have let him purchase it. There is a case that I believe is directly on point with that as well, the United States versus Jeter, the fact in that case is that the defendant and passenger borrowed a car from a passenger's fiance. They were pulled over and stopped. The passenger gave consent to search the vehicle. The government argued that the defendant lacked standing. And then they found drugs in the vehicle. The government argued that the defendant lacked standing to challenge the search because they obtained Miss Floyd's permission to use the car under false pretenses and invalidating the permission. It's pretty much what the state tried to claim today without any type of other evidence other than they say Miss Strawberry never said it. However, the holding in this case is the defendant had the standing to challenge the search. The rationale, if accepted, the government's expansive position would bar the defendant from challenging a wide range of government searches. The implication of their position would not be limited to simply cars. In many other situations where the defendant is in possession of property by permission of another, the government could argue that the possession was obtained through false pretenses and therefore the defendant could not challenge the search. They go on to give examples about the owner and mortgage and a couple of other examples. They move on to say the situation, the property being obtained by a defendant under false pretenses should be distinguished from that in which a defendant never legitimately obtained the property. So the issue is the cases that the state continues to bring up, they never legitimately retained the property. Yes, there was no question at all that these vehicles were stolen. Yes, there is no question. And I do have a case about a hotel I'm going to talk about in a second, but yes, there's no question at all that not only did they find out in the cases of the hotel that there was fraud. What about marriage fraud? You don't have any cases about fraud between people who think they're married and bigamy and property. You don't have any case. Everything is about a stolen car with some drugs and damn fraudulent hotel rooms. There is no case law about bigamy and financial fraud and relationship scams and things of that nature that's more relevant to what's actually going on here. Girl, it's a mess. It's a mess. Ooh, baby, when I tell you my mouth is tired from all of this, my Lord. Okay, but yes, there's no question at all that they did not find any cases. Girl, I'm so tired of these wackadoodle cases he keeps picking up. Your Honor, I'm going to skip a little bit. This is literally just equates to Miss Strawberry tells you, we know, Your Honor, this is literally just, it equates to Miss Strawberry tells you, we know the car. She knows the car exists. She knows the car is coming out of her personal account because that never changed. That's not necessarily true. She knows the insurance is coming out of her personal account that never changes. Mr. Williams drives the vehicle with no issues and that never changes. All of a sudden he gets arrested and now there's a problem. Yes, you're not my husband. You don't get the rights. You don't have rights. Let's just say she was paying. Let's just say all the things that he just said was true. What nullifies that is the fraud, the lies, and the illegal marriage. Because none of that would have happened had you not lied and scammed me. Okay. There's a lot of cases in Georgia that were quoted that same thing happened. Somebody lets someone borrow a car, they get arrested. Now I'm going to report the car stolen because I'm trying to distance myself from him. That is exactly what's happening here. No, but he didn't borrow a car. He lived with this woman for a damn decade. They were allegedly married. That's more serious than, hey, can I borrow your car? Okay, that is exactly what happened here. The state hasn't proven otherwise. Now, in regards to the hotel example, I'm so sick of him in these damn hotels. That kept giving case law is clear on that as well. United States versus Batista. in that case, the defendant was in a hotel room making counterfeit money. Can you please come to the future? This case is from 2004. What are you talking about, sir? The representative of the booking agency called and told the hotel manager, hey, the card that was on file is stolen. The manager calls the police. However, before the manager tried to evict the defendant, police went in, searched it, and saw the counterfeit money. The holding in the case, defendant retained a legitimate expectation of privacy at the time of the warrantless entry into the hotel. In this case, neither the hotel manager nor the police had reached a conclusion that the defendant had fraudulently procured the room. The manager did not ask the police to evict the defendant. The police did not suggest doing so. Neither the hotel manager nor the police knew whether the defendant had obtained the room by fraud. No investigation had been conducted and no cause of ejection had been developed. Defendant still had 2 days remaining on his reservation in the motel, had no affirmative steps to repossess the room. So not only the case is almost right on point with us, the day Mr. Williams was arrested, there's not testimony of a single officer believed that the vehicle was procured by fraud. The day Mr. Williams was arrested, Ms. Shirley Strawberry never filed a report or took any steps to say the vehicle was procured by fraud. I need to get it out of my name. The day he was arrested, even though she knew about it, no steps were taken, no investigation happened. At that point, Mr. Williams was legally driving the vehicle, and that the state never brings up is that he wasn't even in the vehicle when he was arrested. He was he wasn't half a football field away. Apparently he didn't see the video. Thank you for the super. Thank you. Get a cold drink. Okay, thank you very much. I appreciate that, baby. Thank you, Butterfly. Thank you guys so much. Thank you for supporting. You guys are awesome. He wasn't half a football field away. You guys saw the video. Extremely important. No steps were taken. No investigation was done. See how Nesto lies to him? He said he was half a football field away. It was not a precursor to get into the vehicle. There was no underlying basis to show the probable cause. It did not exist at the time. Now, using the state's own logic, the state's own rationale, they failed with the stolen car argument, with the hotel argument, because it needs to be more if they're consenting, and it needs to be more. Now, in regards to the bigamy, that says that it shall be an affirmative defense that prior the spouse has been continuously absent for a period of 7 years. Pretty much the accused did not know the prior spouse to be alive. So that's the excuse now. He didn't know if Edith or Martha were dead. Wouldn't Laverte tell him that that her mother died? He has a surviving child. He has a child with one of those women. You don't think that that one of your children would tell you that their mother passed away? Babe, can you turn the lights on, baby? Thank you, hon. Okay. If the accused reasonably believed that he was eligible to remarry. In regards to the state's two, Your Honor, you can see that from the state's own evidence that Miss Edith took steps to find Mr. Williams. They just didn't locate each other. Edith doesn't watch the Steve Harvey show. She didn't see her ex-husband over there marrying somebody else, Edith or Martha, see him marrying and Shirley screaming across the land, getting engaged, or didn't see it on the internet with over millions of views. They didn't see that. They didn't see Nesto and Shirley in Essence magazine. They didn't see that. Oh, okay. They didn't see Nesto on Married to Medicine. They didn't see Nesto over there on Married to Medicine. Okay. That's what took so long. But at the point where Miss Edith didn't know where Mr. Williams was, she was still granted a divorce. Everything went through. and that was never revoked. No one ever came back and said that's not true. Mr. Williams didn't know because he was never served with anything at the time. He didn't know that it was happening because they couldn't find each other. So the state now has to move to that he reasonably believed that he was eligible to marry. Well, the evidence shows he was, because he remarried in DeKalb to Miss Halliburton. There were no issues. He remarried to Miss Strawberry after Miss Halliburton. There was no issues. He also reasonably believed that he was eligible to remarry. Now, to discuss this little more than there's a case, Dillard versus Shikey. The rule from this case is very simple. Subjective beliefs to marital status of a husband and a wife is irrelevant to the determination of whether a husband's first or subsequent wife has husband's lawful wife at the time of his death. In this case, he had died, and they're trying to argue who was the wife. The biggest thing here is, Your Honor, is the only testimony that the state presented was literally subjective. It wasn't even substantive belief. It is hearsay from her attorney, which knew better because she knew the difference between an annulment and a divorce. So that case is right on point with, there's no evidence that Mr. Williams ever knew or intended to defraud, or intended to get into the marriage with Miss Strawberry, reasonably believing that he was already married to somebody else. This has been good cause law since 1906. So he went and found 100-year-old law, 120 years. 1906, he went, couldn't find anything more recent. He went back to 1906, where accused honestly believed that his wife had secured a divorce, and this belief was induced by reasonable diligence of ascertaining the truth in inference. An inference is authorized that he had no criminal intent in entering a second marriage and therefore not guilty of bigamy. Your Honor, the testimony shows that not only did law enforcement, not only did the investor from the Fulton County investigator from Fulton County District Attorney's Office look into all of this, he couldn't find where Mr. Williams still in a marriage of somebody else. And they literally have the power of the state. If a person in the position couldn't find it, then it's reasonable to believe Mr. Williams believed that he was free to marry. Everything showing that he literally married Ms. Strawberry, and the way their final divorce ended even solidified the fact. That's the reasonable belief that the state never presented otherwise. There's another case, Longstreet. There's another case, Longstreet versus Longstreet, 1949, 75 years ago. Again, this law has been good since 1949 in Georgia. The assumption as a validity of a second marriage can be negative only by disproving every reasonable possibility. The state has not proved anything reasonable possibly. They go on to quote from Brown versus Parks. Oh, well, let me go on there because I don't want to be... In regards, there is a couple of cases that I want to quote, but I'm not going to read all of them. Please don't. Since marriage status has never existed between the parties in the suit, the defendant has never been the wife of the petitioner. It follows that the suit for divorce will not be available remedy for the petitioner. It's important, Your Honor, because what this says is that if it was actually true, if he was actually married to somebody else, and Miss Strawberry and her attorney actually believed that, then the divorce would not be sufficient in Georgia. They would have had to have gotten annulment. The attorney knew that because she was a prosecutor at first with the office, and now she's doing divorce law. Her attorney knew that all of these cases cut against it and has no existing. So if you knew this while you were sitting your big plump behind observing, Why didn't you tell Nesto that he should interject and ask for an annulment and contest the divorce based on the fact that the marriage may not be valid because he's recently found out that he was married to someone else and that they should have an annulment? Why didn't you educate your client as you were sitting there observing? You know what I'm saying? That's what I want to know. There is no testimony that there ever was, because there was an actual divorce every single time, including Miss Strawberry. Even when she claims she figured all of this out, she still hasn't taken the steps, and neither has the district attorney's office. Then she should go ahead and apply for her annulment now. Like, okay, you ain't said nothing but a thing. The final decree of divorce has been entered with respect to an invalid marriage, and a decree may be set aside as void. That's not happened here. The reason why it's not happened here is because there is no bigamy in this case. All these things, I would be over there with my lawyer. Go ahead and get your annulment on top of it. We were divorced and we got an annulment. The state has presented no evidence whatsoever. Miss Shirley Strawberry has an attorney that has the best position to understand that, to know that, and effectively communicate that, not only Miss Strawberry, but the court as well. And it never happened. They still haven't taken any steps. So again, the question is, who is the actual victim here? Is it the mortgage company? He's so dumb. Well, the answer is no. They haven't shown that. Is it Laura Trucks, the physical building where he purchased the vehicle? The answer is no. Miss Strawberry, the answer is no. The testimony shows that she only tried to distance herself from the vehicle and Mr. Williams after he was arrested, not when she found out about the vehicle, not when she figured out the money wasn't coming out. She only did it afterwards. And even when she did it afterwards, she really didn't, because she didn't change any accounts. Everything was still coming out of the same. She didn't say this was fraud. Everything was still the same, and she kept it in the divorce, Your Honor. For all of those reasons, we let me make sure I didn't miss anything. Yes, Your Honor. So at the point where none of this information was known by any law enforcement or the DA or anybody at the time to arrest, no steps have been taken, no investigation have been done that actually produces evidence that Mr. Williams defrauded anyone or anything, that this marriage was bigamous. I do not believe that the state has met their burden. And again, Your Honor, the state did give you 1, 2, 3, 4, and 5. And in these, they talked about how much there are certain phone numbers for certain people, the email addresses and certain people, and they never showed you how that was some type of fraud. That's the problem. The state never tells you where the fraud comes from. They tell you that the victim is because there isn't one, because it didn't happen, and they did not prove the elements of the bigamy. And for those reasons, Your Honor, we're asking that you go back to the beginning when we first argued that Mr. Williams does have standing. They're violating his constitutional rights under the Fourth Amendment, and the evidence that we're asking is to be kept out should be kept out. Thank you. Woo! Understood. ADA, Mr. Wooten. Yes, Judge, I want to hit a few points, just a few counterpoints. There was an argument that was never brought this issue up initially. Well, the reason we didn't bring it up initially, the standing issue was up initially. Then reason we didn't bring it up initially is because it's their burden to prove it. And so we're not going to come into court and tell you like they need to prove it this to win. We didn't bring it up because they didn't prove it, and they put in no evidence as standing. So we realized that and brought it to the court's attention, and that's why there is somewhat of a delay. In any case, the court explicitly said that we could provide additional briefing. So the second thing is the theme that I'm hearing of the argument is who the victim is in this case and this situation. And let's be clear, the victim is Shirley Strawberry. She's the victim of identity fraud. She's the victim of bigamy. She is the victim. That's unequivocal. So there's any question, that's the answer. There's an objection raised that Miss Strawberry knew the vehicle existed in 2020 and therefore she couldn't have been fraud. Well, her knowledge of the vehicle existing in 2020, that's not contested. We, the state, brought out the evidence. The question is, she didn't realize, when did she find out that the information had been used, that her information had been used without her knowledge? And she testified that was in 2022 after the defendant was arrested. So don't think there's any relevance as to the fact that she knew the vehicle existed. We're not contesting that. There's an argument that where is the evidence that Mr. Williams knew that the marriage to Miss Strawberry was bigamous? No. One, I go back to where I began at the beginning of the argument, is it is the defendant's burden to prove the question of standing. So the defendant could have testified, I didn't know, or I thought my first wife was dead, or I thought we were divorced. They didn't establish any of those facts because, he probably doesn't want to get on there and perjure himself because that would be bad. They didn't establish any of those facts, number one. Number two, how do we know that the defendant knew about the marriage or about the previous marriages or the existence of them? Well, we know that if you look at the state's exhibit 3, the state's exhibit 4, where the defendant lied on his marriage applications, and we know this, the state's exhibit 3, he says that he was 0 previous marriages when he absolutely had a previous marriage to Miss Miller. So lie number 1. And then if you look at the state's exhibit 4, where the defendant says he had 3 previous marriages and says that he had, and each of those were dissolved, that's lie number 2. We know that we know that's not the case. The marriage, at least to Miss Halliburton, didn't dissolve until 2021. That's state's exhibit number 5. In the document where he lies and says the marriage was dissolved by divorce from December 16th, 2014. So you take 2 lies, 2 marriages, 2 marriage license applications, and provide some pretty good circumstantial evidence that the defendant knew that these prior marriages existed. Otherwise, why was he trying to conceal them through lies? Additionally, there's been a lot of argument and a lot of case law on distinction between divorce and annulment. I would start with number 1, and that has no relevance to the issues here. What a divorce attorney did in the divorce proceeding was literally no relevance to what's going on in this courtroom. We put up the evidence about the marriages were bigamous. We put up the evidence, circumstantial evidence, that the defendant knew that his marriages were bigamous based on the prior lies in his marriage license applications. And then number 2, on that issue, I would ask the court, just indulge this because I know the answer to the question, and I would make the representation as an officer of the court that I watched those hearings, those divorce hearings, and that happened was the judge in the divorce said, hey, based on the bigamy and the void marriage, don't you want an annulment? And the response was, well, we've already initiated the divorce proceedings and we want to just get this over. That's exactly what they said. She sure did. And we're already here, so let's just do it this way. Now I'm making a comment as to whether that's proper at all, but this idea that the annulment possibly was never brought up, number 1, that's not true, and that is very true that that's not true. Number 2, it's just has to, no effect on the standing issue. There's also no argument that what the state has proven as it relates to Exhibit 1 and the false information that we've shown is lies, but not fraud. Well, if you go back to the basic definition of fraud, fraud is a lie. Hello, with the intent to gain property or some, to gain something. So we've shown that the lie, which is all the fake information on the application, and we've shown the gain, which is the truck itself. There was also, I think, an argument that Shirley Strawberry never said that fraud was committed. She testified, Your Honor, that she told the police when she found out the fraudulent purchase that fraud was committed. She testified that she told the financing company that there was fraud in the purchase of the vehicle and they wouldn't do anything about it. And then she said that if she'd known, she would have brought it up to the DA's office, she would have. And then once we brought her the document, she said, oh yeah, that's definitely fraud. I will also just distinguish a couple of cases that were brought up. First, the 10th Circuit, United States, Rivera. This is the case that talks about the person whose permission to use the conveyance and therefore have a reasonable expectation of privacy. That is true with an asterisk. The asterisk being if they had a legitimate permission. If the person who gave permission gave them permission with the full knowledge and understanding and the full set of circumstances beyond the request of the possession of property. So number one also was no evidence. Again, going back to the beginning, it is their burden of proof and standing that there's no evidence he had permission to use the vehicle with Miss Strawberry, having full understanding of the situation being a bigamy and identity fraud, number one. And two, our cases support this exact proposition, which is that, yes, when you have permission to use a conveyance, to be in a residence, to be in a hotel room, that you have a reasonable expectation of privacy, except when you obtain that permission or procure the permission by fraud. So you look at any of these cases that we've cited, then the person who had the laptop computer, they brought it with a stolen credit card. They did not have permission to carry the computer out of Best Buy or whatever. Yes, of course they did. But that permission legitimate? No, because they stole the credit card. And so I don't think that case is at odds with anything that we presented. Also, I will just distinguish United States versus Jeter. That's the district court's decision that is no binding effort on the court. It's out of Utah. And so I would ask the court not to give too much weight to this case. And with that, unless the court has any other questions, that's all I've got. Okay, Hoover, I would ask the court to read the cases, especially the ones I've quoted, because the state has said it's not what those go for. Not one of them says where's the asterisk. So please read the cases, Your Honor, to see how the cases in the state quoted are completely dispositive of the issue that we have here. And I think mine are more on point. Thank you. His case from 100 years ago. Thank you all. I'm going to venture to get an order out as soon as possible, and we will have an order emailed out to both parties. I think if I find that the state has shown that there is no expectation of privacy and the defendant lacks standing, Attorney Hoover, if you want to appeal, let me know. I'll give you a certificate of immediate review. I believe that if I find that they do have standing, then I think the state has an automatic right to appeal. So I will get an order out, email it to both of you as soon, get it out to both of you, and we'll know as how much time you have if you want to appeal the court's ruling. All right. Thank you all. Well, what we do know, first of all, praise and hallelujah, we made it through 117 pages. Okay, that's number one. Okay. We made it through the whole document. I didn't think we were going to do it. That's number one. Number two, Attorney Hoover is in the process of appealing. It was denied, and Judge Dunaway did issue a certificate of immediate review, and that was done maybe a couple of weeks ago. I'm logged out right now, and I'm not going to log back in. It was maybe two or 3 weeks ago, and this is now posted because the appellate court is going to have to read through this and weigh the arguments, and also Judge Dunaway's decision. And even though law enforcement was not aware of all of the fraud when the decisions were made, at the end of the day, the fraud was bubbled up in time, which made him not have permission for the use of the vehicle as a husband, as a spouse, because of the bigamy, because of the fraudulent marriage, because of the identity fraud and identity theft, all of the. Okay, you guys, hold on a second. Whew. Yes, we're still here. Black Swan. I told you guys it was a movie. This was it took it was 117 transcript pages. It was a book. It was a whole entire book. I took one break for 5 minutes in that reading. That's why I said to you guys, I'm not reading that again. I'm just not. Too much. Anyway, it was good hearing it again. I'm glad that I got to actually listen to it with you guys. We already know what happened. Number one, Judge Dunaway, like I just said in the audio, Judge Dunaway did deny the motion to suppress. He gave the certificate of immediate review. I don't know why, how Hoover let that damn thing expire. It had to be reissued, and it just got reissued, I think, sometime last week. Hoover has 10 days to file his appeal, so it should be coming soon. And girl, good for him. Nesto gonna be there till 2050, and that's his business. You know what I'm saying? Like, listening to this again just solidifies what we already know. They don't have any argument. And I think that once the appellate court, once another group of reasonable adults read this fugazi melodrama and hear Nesto's shenanigans and the fact that this guy was in a bogus situation, he does not have any rights to the vehicle. I mean, they're not going to care. They don't have a horse in this race other than they have a case to review. And once they reconcile the fraud that took place for the procurement of the vehicle, not to say that the Fourth Amendment issue doesn't matter, but knowing what we know now, at the end of the day, the bottom line is the vehicle was procured in like a twofold fraud, and he doesn't have any rights to a presumption of privacy, or he doesn't have any rights to the presumption of privacy or whatever else it was. I'm having a hard time thinking at this moment because now I'm getting tired. It's a wrap. But let Hoover file whatever he needs to file. We enjoy a good read session, And that's it, and that's all. Okay. I can't hope he's doing like and his friend with 30, 25, and 50. Girl. Okay. Anyway, if you have not hit the thumbs up, hit the thumbs up for me. I appreciate all of you guys who've been here and listened and enjoyed. Thank you to everybody. The likes are up there. We had almost 500 likes. If you haven't hit the like button, get us to 500. I appreciate that so much. That helps hype the video. Um you guys, what's going to be the next one? If you remember the epic read of the state's response to the motion to suppress, remember the 277-page document? It took me 2 days to read it. That one was crazy. I don't know. That might have to be like over a weekend if we listen to that, but that was the one where we had it was chock full of receipts. It was crazy. I don't even think we read the whole thing. I think we read the whole entire like filing, but as far as all of the receipts that Wooten put with it, it was crazy. Anyway, guys, this was fun. Thank you, KK. KK, like I said earlier, I don't know if you were here when I mentioned it, but I know you had bubbled up a couple. And I'm just kind of compiling a list. I've got it in my notes, some links to a few videos that you guys have been bubbling up. I'm gonna let y'all go, guys. I am exhausted. Anywho, you would think I just reread that whole thing with you guys. And I got to sit back, enjoy, and listen and be with you guys in the chat, which was really, 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 really nice. Again, thank you guys for all of you guys who support and sent supers and memberships and all of the things. You guys are awesome. Thank you to everybody who hit the thumbs up. Any new subscribers, just being here means a whole lot. So thank you for that. I will see you guys tomorrow. Tomorrow we do have a special guest coming to see us. If you don't know who that is or what's going on, what special guest, just go back to the beginning. If you missed like the first 20 minutes, all of that will be explained. Okay. You guys have a wonderful evening. I will see you guys tomorrow. School is out again, if you can believe it. Um, I'm hoping maybe they'll go back to school on Thursday. Who knows? But girl, okay. Anyway, I got to get up early and get my husband out the door, do all of the things that I do. So you guys have a wonderful evening. Thank you guys again for like the third, fourth, fifth time, but that's just how much it means to me. Where is your hype on Miss Piggy Braxton? Hey, Miss Piggy Braxton. I don't know, boo. Maybe it's when it's over. I'm not sure, but yes, if you can hype me up, okay? I appreciate y'all so much, okay? All right, you guys. Good night. It's been a blast, okay? Good night.